Secondary Education Shiksha Sadan, 17. 110002. Legal Studies. Class 12 WWW. CBSE Academic. NIC. In. Legal Studies for Class 12. Price, Unpriced Edition. Edition, First Edition 2014. Second Edition 2023. This book or part thereof may not be reproduced by any person or agency in any manner. Published by Director, Academics, Central Board of Secondary Education. Shiksha Sadan, 17, Institutional Area, 17, Rouse Avenue, Delhi 110002. Design and Layout, Lakshmi Print India. 556, GT Road, Shadara, Delhi 110032 www. CBSE Academic. NIC. In www. In www. CBSE Academic. NIC. In. Preface. CBSE first published the textbooks of legal studies in the year 2014, and since then numerous feedback and suggestions from both teachers and students have been received, invariably underlining the need to bring out a revised edition to provide up-to-date information reflecting the current state of the law and legal policies in the country. The aim of the present edition is, therefore, to improve the content in terms of clarity, structure, presentation and relevance. Content has been reorganized in a more logical and intuitive way, and most recent topics such as intellectual property rights, legal entities, etc. have been added to give it a contemporary and more relevant look. We have also taken special care to take into account the feedback of teachers and students to make this edition even more student-friendly and accessible. The newly added chapter on intellectual property rights explains the various forms of intellectual property, their purpose, and benefits, as well as the requirements for obtaining and maintaining protection. It also discusses the international considerations governing IP rights. The chapter on sustainability and law deals with the inclusion of international provisions in municipal law in India and the legal framework for preserving the environment. Similarly, the chapter on legal entities explains different types of entities such as sole proprietorships, partnerships, limited liability partnerships, private and public limited companies, serving as a valuable resource for the legal requirements associated with each type of entity, and their advantages and liabilities. Our hope is that this edition will meet the expectations of teachers and provide students with the tools and knowledge necessary to succeed in their legal studies and beyond. Special thanks are due to Prof. James J. Nedumpara for guiding the team with academic input, editing, and overall coordination. We also place on record our appreciation for the efforts put in by Ms. Disha Grover, Ms. Neelu Soft, Ms. Sabrina Bansal, Ms. Geetika Agrawal, Ms. Charu Tiwari, and Ms. Sana Bhatta, and for demonstrating exemplary commitment to providing high-quality educational resources and revising it multiple times. Their collaboration and coordination and attention to detail have resulted in a comprehensive and updated textbook that will undoubtedly benefit countless students and teachers. We are grateful for the time and energy they have invested in making this textbook an even more valuable learning tool. We would appreciate comments and feedback on this book, and they would be considered for future editions. Team CBSE WWW. CBSE Academic. NIC. In. Acknowledgement. Guidance and support, Ms. Nidhi Chibbar, IAS, Chairperson, Central Board of Secondary Education. Dr. Joseph Emmanuel, Director, Academics, Central Board of Secondary Education. Material production for the first edition. Prof. James J. Nedumpara, Professor, Jindal Global Law School, OP Jindal Global University, Sonipat, Delhi. Mr. Sandeep Kindo, University of Wisconsin, Madison, USA. Mr. Vinay Kumar Singh, Indian Society of International Law, New Delhi. Dr. Anil Kumar Thakur, Punjab University, Chandigarh. Ms. Anjali Bansal, Punjab University, Chandigarh, Mr. Ram Shankar, Assistant Professor and Joint Director, GANE, CBSE. Content Updation Group, 2nd edition, Prof. James J. Nedupra, Head of the Center for International Trade and Investment Law, Indian Institute of Foreign Trade, IIFT, New Delhi, Ms. Disha Grover, Delhi Public School, Mathura Road, New Delhi. Ms. Neelu Softwig, Sun City School, Gurugram, Ms. Charu Tiwari, Sanskriti School, New Delhi. Ms. Sana Bhatta, Bloom Public School, New Delhi. Ms. Sabrina Bansal, Delhi Public School, R.K. Puram. Ms. Geetika Agrawal, Delhi Public School, Sec 45, Gurugram. Legal Inputs and Book Review, Akshay Chitkara, Advocate, Delhi High Court. CBSE Coordinator, Mr. Al-Hilal Ahmed, Joint Secretary, WWW. CBSE Academic. NIC. In 8, 7, 4, 5, 6, 3. Contents. Unit 1 Judiciary 1 to 30. Unit 2 Alternative Dispute Resolution in India, ADR, 31 to 50. Unit 3 Topics in Law I, Business Laws, 51 to 92. Chapter 3, A, Law of Contract 53. Chapter 3, B, Law of Torts 62. Chapter 3, C, Law of Property 72. Chapter 3, D, Intellectual Property Law 80. Unit 4 Topics in Law 2, General Laws, 93 to 124. Chapter 4, A, Law and Sustainable Development 95. Chapter 4, B, Forms of Legal Entities 101. Chapter 4, C, Criminal Laws in India 112. Unit 5 Concept of Human Rights 125 to 160. Chapter 5, A, Human Rights in India 127. Chapter 5, B, Human Rights Violations, Complaint Mechanism, Quasi-Judicial Bodies, 147. Unit 6 International Law 161 to 180. Unit 7 Legal Profession in India 181 to 194. Unit 8 Legal Services 195 to 205. 1. 2 www. CBSE Academic. NIC. In Unit 1. Judiciary. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 3. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Judiciary. Learning outcomes. Students will be able to I. Trace the history of the origin and development of Indian judicial system in India. 2. Know the structure of judiciary in India. 3. Explain the jurisdiction of the Supreme Court of India. IV. Explain the jurisdiction of the High Courts. V. Understand the working of subordinate courts. VI. Identify the hierarchy of judicial system in India. 7. Discuss the role of tribunals in complementing and supplementing the role of judiciary in India. 8. Explain the concept of judicial review in India. X. Understand the scope of judicial review in India. A. Structure, hierarchy of courts, and legal officers in India. The Constitution of India lays out the framework of the Indian judicial system. India has adopted a federal system of government which distributes the law and acting power between the center and the states. Yet the Constitution establishes a single integrated system of judiciary comprising of courts to administer both central and state laws. The Supreme Court located in New Delhi is the apex court of India. It is followed by various high courts at the state level which function for one or more number of states. The high courts are followed by district and subordinate courts which are popularly known as the lower courts in India. To supplement the functioning of the courts, there exist specialized tribunals to adjudicate sector-specific claims such as labor, consumer, service matter disputes. I. Supreme Court of India. The Supreme Court of India came into being on the 28th of January 1950. It replaced both the Federal Court. Unit 1, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 4. Unit V Unit 7 Unit V. Of India and the Judicial Committee of the Privy Council, which were the apex of the Indian court system, under the colonial era. The Constitution of India as it stood in 1950 envisaged a Supreme Court with a Chief Justice and 7 judges. The Parliament was granted the power to increase the number of judges in the coming years. At present, the total strength of the Supreme Court is 34 judges including the Chief Justice of India. The Supreme Court, Number of Judges, Amendment Bill, 2019, the Supreme Court, Number of Judges, Amendment Bill, 2019 was introduced in Lok Sabha on August 5, 2019. The bill amends the Supreme Court, Number of Judges, Act, 1956. The Act fixes the maximum number of judges in the Supreme Court at 30 judges, excluding the Chief Justice of India. The bill increases this number from 30 to 33. Sources, web links. AIE. High Courts India consist of 25 high courts at the state and union territory level. Each high court has jurisdiction over a state, a union territory or a group of states and union territories. Below the high courts exists a hierarchy of lower courts functioning as civil courts and criminal courts as well as the specialized tribunals. The Madras High Court in Chennai, Bombay High Court in Mumbai, Calcutta High Court in Kolkata and the Allahabad High Court in Allahabad are the first 4 high courts in India. The Andhra High Court and Telangana High Court are the newest high courts, established on the 1st of January 2019 according to Andhra Pradesh Reorganization Act, 2014. A. I. E. District and Sub-Ordinate Courts. The courts that function below the high courts are popularly known as subordinate judiciary. They comprise of district and sub-ordinate courts. Each state is divided into judicial districts presided over by a district and sessions judge. The judge is known as a district judge when he presides over a civil case and a sessions judge when he presides over a criminal case. The district judge is also called a metropolitan sessions judge when he is presiding over a district court in a city which is designated as a metropolitan area by the state government. District judges may be working with additional district judges, depending upon the judicial workload. The district judge is the highest judicial authority below a high court judge. The district court also holds appellate jurisdiction and supervision over all sub-ordinate courts below it. On the civil side, the sub-ordinate courts below the district court include, in ascending order, Junior Civil Judge Court, Principal Junior Civil Judge Court, Senior Civil Judge Courts, also called sub-courts. Subordinate courts on criminal side, in ascending order, include Second-Class Judicial Magistrates Court, First-Class Judicial Magistrate Court and Chief Judicial Magistrate Court. Apart from the sub-ordinate courts, district municipal courts also form a part of this hierarchy. They are the lowest in order of handling matters of civil nature and function below the sub-ordinate courts. Usually, these are controlled by the district courts of the respective district. Their pecuniary limits, meaning the court's ability to hear matters up to a particular claim for money, are notified by respective state governments. A. 2. Salient features of Indian judiciary. A. India is a common law jurisdiction taking its precedence from the British tradition of common law. India has adopted a similar model. Under the scheme of the common law system, the decisions, orders and judgments, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 5. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Developed by the judges in India help in the creation and development of laws and legal principles, which becomes binding precedents for all subordinate courts in the hierarchy. Therefore, courts play a vital role in creating laws, especially where gaps in law exist, and the legislature or executive have failed to enact laws. Thus, apart from administering civil and criminal justice, courts and judges serve a vital function in the federal setup of the country. Opposed to this model is a concept of civil law system followed in countries such as Germany, Russia, and continental Europe. The main difference between common and civil law is with respect to the source of law. Under common law, judiciary can make laws through judicial decisions of courts. However, under civil law, only the legislature or executive has the power to create laws and rules. This salient feature of Indian judiciary in following a common law model further strengthens the role of courts in India. B. Adversarial model of dispute resolution. Courts in India follow the adversarial system of adjudication as opposed to the inquisitorial model followed in several civil law countries. In an adversarial model, the role of lawyers representing the party becomes vital. Lawyers of the opposing parties present their cases before a neutral judge who in turn provides a decision based on the merits of the case, as presented by the lawyers. In the inquisitorial system of law, on the other hand, judges are more proactive in adjudicating the matter. Rather than acting as neutral judges, they have rights to inquire and probe into the matter, much like a police. Here the role of lawyers representing the party and the role of judge cumulatively becomes important in determining the manner in which a civil case or criminal trial proceeds. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 6. Unit V Unit 7 Unit V. A. 3. Legal officers in India. Certain legal officers at the union and state level exist to advise the executive wing of the government. These law officers derive their mandate either from the constitution or other statutory enactments and rules. A. Attorney General of India. The Attorney General is the first legal officer of the country. The Attorney General of India is appointed by the President of India under Article 76 of the Constitution, which states that he can hold the office during the pleasure of the President. The Attorney General must be a person qualified to be appointed as a judge of the Supreme Court, possessing adequate legal practice or have served as a judge for a requisite duration as mandated by the Constitution. The first Attorney General of India was M. C. Setalvad. Attorney General gives advice to the Government of India upon such legal matters, which are referred or assigned to him by the President. Also, he performs such other duties of a legal character that are referred or assigned to him by the President or conferred on him by or under the Constitution or any other law. In the performance of his official duties, he has the right to audience in all courts in the territory of India. He has the right to speak or to take part in the proceedings of both the Houses of Parliament and their joint sittings but without a right to vote. He has the right to speak or to take part in the meeting of any committee of the Parliament of which he is named as a member but without a right to vote. He enjoys all the privileges and immunities that are available to a member of Parliament. In discharge of his functions, the Attorney General is assisted by a Solicitor General and 4 additional Solicitors General. The position of the Solicitor General and additional Solicitors General is not recognized in the Constitution. However, they are governed through rules enacted by the Parliament. B. Advocate General. Similar to the Attorney General of India, the position of Advocate General exists at the state level. An Advocate General is a senior law officer who acts as a legal advisor to the state government. According to Article 165 of the Constitution, Advocate General is appointed by the Governor of the respective state. The Advocate General is the chief legal advisor of the state and performs duties of a legal character including representing the state before the courts either through himself, herself or through the law officers or pleaders appointed by the state. The qualification required for appointment as an Advocate General is similar to that of a judge of a high court. The office of an Advocate General is held during the pleasure of the Governor, who also determines the nature of remunerations for the Advocate General. Additional Advocate Generals are also appointed to assist the office of the Advocate General. B. Constitution, rules and impartiality. The judiciary in India derives its powers and functions from the Constitution, which till date remains the fundamental legal text for the functioning of Indian democracy. BII independence of judiciary as a constitutional safeguard. Article 50 of the Indian Constitution lays the rule of independence of judiciary. This is understood as judiciary's autonomous status, separate from the executive or legislative wings of the government. Independence of judiciary helps in the maintenance of rule of law, ensuring good governance and creating a free and fair society. The independent status of the judiciary and roles to be performed by it can be understood as two sides of the same coin. In this context, one must understand the reasons for granting a special status to the judiciary. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 7. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. First, judiciary's independence is linked to its role as the watchdog in a democracy. It monitors and maintains the checks and balances over the other arms of the government. Thus, judiciary emerges as a mediator when any organ of the government exercises excess power, which tends to violate the larger societal or individual interest. For instance, the Indian police has extensive powers for crime detection and gathering evidence for prosecution of criminals. It is common for the police to interrogate suspect criminals in order to gather the best evidence of the crime. However, such powers should not impinge upon the rights of the accused or the suspected criminal. An accused cannot be coerced into giving statement pointing to his/her guilt. This right has been constitutionally guaranteed to the accused under Article 23 of the Constitution, which states, "No person accused of any offence shall be compelled to be a witness against himself." Judiciary steps in when such delicate interests are at loggerheads. Similarly, when there is a thin line of difference, as in case of a police exercising their power to gather witness, in the exercise of the legitimate and excess right of a state organ, the role of judiciary becomes vital. Second, in order to ensure that constitutionally guaranteed freedoms such as freedom to speak in public or peacefully assemble, are interpreted as per the true constitutional philosophy, judiciary has been kept free from any external pressures. This is particularly useful when judiciary is interpreting a case of conflict between the government, political party in power, and certain protesting people of the civil society who have peacefully articulated their opinions on social issues, for example, crime against women. Third, judiciary acts as a guardian of fundamental rights which are constitutionally granted to every citizen in India. Independence of judiciary was carved out during the formation of Indian Constitution as India was transitioning from a feudal to a democratic order. It was done to fully translate the well-knit provisions of extensive rights guaranteed under the Constitution into the lives of average citizens. Our Constitution grants us unique rights such as civil and political rights, e.g., the right to life, right to freedom of discrimination based on religion, race, caste, sex, or place of birth, economic, social, and cultural rights, e.g., freedom to practice any religion, protection of interests of minorities. An independent and impartial judiciary has empowered Indian citizens and performed this role. Illustratively, one may look into the role of court in giving an expanded meaning to Article 21 of the Indian Constitution, which talks about a general right to life and personal liberty. For example, within this freedom, the Supreme Court has held that a street vendor has a right to operate on streets as selling products on street is linked to his livelihood and daily living, which is protected under Article 21. Similarly, the Supreme Court has also stated that those who are aged, disabled and destitute in India, including men and women, have a right to food, which is most essential for their survival. State has a corresponding duty to provide them with food. This right has been read into the general right under Article 21. Therefore, the court is performing the role which it was granted at the time of the drafting of Indian Constitution. Even though the drafters did not include specific rights such as livelihood and food within the constitutional ambit of enforceable fundamental rights, they are now made available to the citizens of India as matters of rights. This has been possible only by the interpretation and rule-making function of the courts in India. Fourthly, independence of judiciary is vital for the respect of due process of law. Due process of law means that the state must respect all the legal rights that are owed to a person and conform to the norms of fairness, liberty, fundamental rights, etc. Only an independent judiciary can make this concept operational. In the domain of criminal law as well, independence of judiciary is linked to the granting of a fair trial to the accused. This becomes extremely important even when the accused are foreign nationals or persons who have committed crimes against the state, e.g., terrorists. Therefore, independence of judiciary remains a vital and core principle even in the modern democracy. BIE provisions relating to the judges' independence of judges is crucial to ensuring independence of judiciary. The following legal provisions, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 8. Unit V Unit 7 Unit V. Mandate judges' independence and impartiality. Once appointed, judges are provided with a security of tenure till they reach a retirement age. This age remains 62 for the High Court judges and 65 for the Supreme Court judges. Judges are not allowed to practice as advocates in the same or equivalent courts post their retirement. For example, a retired High Court judge can practice in the Supreme Court, but is prevented from practicing in the same or other high courts. This ensures that ex-judges practicing at the bar do not influence the decision of the bench, with whom they may have presumed familiarity. Judges cannot be easily removed from their office except for proven misbehavior and incapacity. The legal process is kept stringent to ensure security of tenure of the judges. The salaries and allowances of judges are fixed and not subject to vote of the legislature. Judges derive their salaries from the Consolidated Fund of India, for the Supreme Court, and Consolidated Fund of State, in case of high courts. Their emoluments cannot be altered to their disadvantage except in the event of financial emergency. Even the judicial conduct of the judges has been kept immune from examination by other constitutional organs. The conduct of judges of both the Supreme Court and High Courts cannot be discussed in Parliament or state legislature, except when a motion for removal of a judge is being presented to the President. Supreme Court of India has been authorized to have its own establishment and to have complete control over it. It is further authorized to make appointments of officers and staff of the court and determine their service conditions. Therefore, one can conclude that independence of judiciary is a constitutionally conferred protection. B. 2. Role of Indian judiciary. Indian judiciary comprises of the Supreme Court, High Court, subordinate courts and other tribunals. The role of these courts along with their composition, powers and procedures for functioning have been elaborated in the Constitution. B. 2. I. Different roles of the Supreme Court of India. The Supreme Court of India primarily exercises the role of an adjudicator and interpreter. This is explained through different jurisdictions vested with the court. A. Supreme Court's role as an adjudicator and interpreter can be understood through the original and appellate jurisdiction vested with the court. Under Article 131 of the Constitution, the Supreme Court is granted original jurisdiction. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute, a. between the Government of India and one or more states, or b. between the Government of India and any state or states on one side and one or more other states on the other, or c. between two or more states, if and insofar as the dispute involves any question, whether of law or fact, on which the existence or extent of a legal right depends, provided that the said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagements, and/or other similar instrument which, having been entered into or executed before the commencement of this Constitution, continues in operation after such commencement, or which provides that the said jurisdiction shall not extend to such a dispute. Such disputes must involve some question of law or fact on which the existence or extent of legal rights can be adjudicated. For example, the dispute between the sharing of river or other. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 9. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Natural resources between two states in India can be directly brought to the Supreme Court under exercise of its original jurisdiction. Article 32 of the Constitution further gives an extensive original jurisdiction to the Supreme Court for the enforcement of fundamental rights of the citizens, through issuing directions, orders and writs. This is popularly known as the writ jurisdiction of the court. Article 32 of the Constitution gives an extensive original jurisdiction to the Supreme Court in regard to enforcement of fundamental rights. It is empowered to issue directions, orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari to enforce them. 1. Habeas corpus, i.e., to order the release of person is unlawfully detained. 2. Mandamus, i.e., to order to a public authority to do its duty. 3. Prohibition, i.e., to prevent a subordinate court from continuing on a case. 4. Quo warranto, i.e., to issue directive to a person to vacate an office wrongfully occupied. And 5. Certiorari, i.e., to remove a case from a subordinate court and get the proceedings before it. The appellate jurisdiction of the Supreme Court can be invoked by a certificate granted by the High Court. Appeal to the Supreme Court may be made against any judgment, decree or final order of a High Court in both civil and criminal cases. Like the exercise of original jurisdiction, these cases must involve a substantial question of law as to the interpretation of the Constitution. Substantial questions of law as highlighted above connote questions of law or fact on which the existence or extent of legal rights can be adjudicated. Appeal in constitutional matters. Under Article 132(1) of the Constitution of India, an appeal shall lie to the Supreme Court from any judgment, decree or final order of a High Court whether in civil, criminal or other proceedings, if the High Court certifies under Article 134A that the case involves a substantial question of law as to the interpretation of this Constitution. Appeal in civil cases. Article 133 provides that an appeal shall lie to the Supreme Court from any judgment, decree or final order in a civil proceeding of a High Court only if High Court certifies under Article 134A, a, that the case involves a substantial question of law of general importance, and b, that in the opinion of the High Court the said question needs to be decided by the Supreme Court. Appeal in criminal cases. Article 134 provides that an appeal shall lie to the Supreme Court from any judgment, final order or sentence in a criminal proceeding of a High Court. This appeal can be in two ways, without a certificate of High Court and with a certificate of the High Court. An appeal lies without the certificate if the High Court, I, has on appeal reversed an order of acquittal of an accused person and sentenced him to death. E. has withdrawn for trial before itself any case from any court subordinate to its authority and has in such trial convicted the accused person and sentenced him to death. Special leave to appeal. Under certain special circumstances, an appeal may lie directly to the Supreme Court from any court in India under Article 136 of the Constitution. This is special leave petition or special leave to appeal. According to Article 136, an appeal can be made to the Supreme Court directly from any order, decision, decree, judgment, etc. given by any court or tribunal in India. This power of the Supreme Court is discretionary and Honorable Court may or may not allow special leave to appeal to any person. B. Advisory jurisdiction. Supreme Court's advisory jurisdiction may be sought by the President under Article 143 of the Constitution. This procedure is termed as presidential reference and is recognized as the advisory jurisdiction of the court. Article 143 reads, if at any time it appears to the President that a question of law or fact has arisen or is likely to arise and b. the question is of such a nature and of such public importance that it is expedient to obtain the opinion of the Supreme Court upon it, she may refer the question for the advisory opinion of the court and the court may, after such hearing as it thinks fit, report to the President its opinion thereon. In Re Kerala Education Bill case, 1958, the Supreme Court laid down the following principles: sad face, the Supreme Court has under clause 1, a discretion in the matter and in proper case and for good reason to refuse to express any opinion on the question submitted to it. B. It is for the Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 10. Unit V Unit 7 Unit V. President to decide what question should be referred to the court and if he does not entertain any serious doubt on the other provisions, it is not for any party to say that doubts arise also out of them. C. The advisory opinion of the Supreme Court is not binding on courts because it not a law within meaning of Article 141. But in Re Special Court Bill case, 1979, the Supreme Court held that its advisory jurisdiction are binding on all courts in the territory of India. It also held that the Supreme Court is under duty under Article 143 to give its advisory opinion if questions referred to it are not vague and of a political nature. C. Supreme Court as an activist. The Supreme Court of India is considered the sentinel key and protects the fundamental and constitutional rights of the people. There have been several instances where the higher courts have taken cognizance of any matter of social, political and economic importance on its own behest or on the basis of a letter or any submission before the court. Public interest litigation. So far we have seen the constitutional imperatives that permit the Supreme Court to adjudicate and advise on disputes coming from the subordinate courts, individuals exercising writ jurisdiction and the President of India. In the recent years, the Supreme Court has relaxed its locus standi, meaning the right of a party to appear and be heard by a court, and has permitted public-spirited citizens and civil society organizations to approach the court on behalf of the victims for better administration of justice. On other accounts, the court has on its own initiative started cases of public importance called suo motu actions. For instance, it has summoned and reprimanded state authorities for their apathy and lack of diligence in running child care homes in the states. All this has been possible through the judicial activism of the Supreme Court through public interest litigation, Janhit Yachika, PIL. This extraordinary jurisdiction has been invoked either through writs or even by writing letters to judges, whose modalities are maintained under the guidelines for PIL enacted by the court. The first ever PIL is listed as Husainada Khatun vs. State of Bihar and dates back to 1979. A public interest activist lawyer filed this case on behalf of thousands of prisoners of the Bihar jail against the inhuman conditions of the prison. A Supreme Court bench headed by Justice P.N. Bhagwati declared the right for free legal aid and expeditious trial of these prisoners, which ultimately led to their release. Since then, PILs have encompassed several issues including socio-economic rights, freedom from bonded labor, legal entitlements, right to food, right to work, environment issues, clean air and water, and political reforms, disclosure of assets by members of the executive, disbursement of natural resources done by the government. The progress of PIL has thus seemed to incorporate several issues. Yet common characteristics encompass these litigations. These characteristics include: PILs can be termed as non-adversarial litigation that pits the interest of one party over the other. Rather than focusing on traditional litigation of adversary character, PILs are recognized as tools for social change. PILs are based on the tenets of citizen standing and representative standing, which expands the rights of third parties to approach the court. PIL from its inception is modeled on remedial nature, which aims at creating a dynamic, welfare-oriented model of judiciary. PIL thus incorporates the directive principles whose claims cannot be brought directly to the courts, into the domain of fundamental rights under Part 3 of the Constitution, which can be invoked before the courts as a matter of rights by the citizens of India. Therefore, PILs are creating new rights and laws within the realm of the state. These laws are also democratizing citizens' access to justice, thereby strengthening the democracy in India. PIL further strengthens the role of judiciary as a monitor and watchdog agency. Fear of being dragged to the court via PIL has improved the quality of several social institutions in the country, such as jails, protective homes, mental asylums, etc. However, with the advent and growth of PILs, they have also been misused for private gains. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 11. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. And led to frivolous litigation on unnecessary issues. They have also been criticized for judicial overreach and stepping into the shoes of legislature. Public interest litigations, a powerful tool for judicial activism. Given below are a few of many instances where the PIL admitted by the Honorable Supreme Court added a new dimension to the Indian judicial system. Ganges pollution case. 3 landmark judgments and a number of orders against polluting industries numbering more than 50,000 in the Ganga basin passed from time to time. A substantial success has been achieved by way of creating awareness and controlling pollution in the river Ganges. In this case, apart from industries, more than 250 towns and cities have been ordered to put sewage treatment plants. 600 tanneries operating in highly congested residential area of Kolkata have been shifted out of the city and relocated in a planned leather complex in the state of West Bengal. A large number of industries were closed down by the court and were allowed to reopen only after these industries set up effluent treatment plants and controlled pollution. As a result of these directions, millions of people have been saved from the effects of air and water pollution in Ganga Basin covering 8 states in India. Vehicular pollution case. Against vehicular pollution in India, the Supreme Court delivered a landmark judgment in 1992. A retired judge of the Supreme Court was appointed along with 3 members to recommend measures for the nationwide control of vehicular pollution. Orders for providing lead-free petrol in the country and for the use of natural gas and other mode of fuels for use in the vehicles in India have been passed and carried out. Lead-free petrol had been introduced in the 4 metropolitan cities from April 1995. All new cars registered from April 1995 onwards have been fitted with catalytic converters. COG outlets have been set up to provide CNG as a clean fuel in Delhi and other cities in India apart from Euro 2 norms. As a result of this case, Delhi has become the first city in the world to have complete public transportation running on CNG. Oleum gas leak case. This is a landmark judgment in which the principle of absolute liability was laid down. The fertilizer plant was situated very close to human habitation, and the court held that the carrying on of a hazardous industry in such proximity to population could not be permitted, and the factory was relocated. The deep pocket principle was also laid down in the instant case. This judgment also ushered in a period of dramatic legislative progress in India. The Parliament added an entirely new chapter to the 1948 Factory Act, incorporating sections almost verbatim from the judgment. The Public Liability Insurance Act was passed and the policy for the abatement of pollution control was established. Moreover, the Environment Protection Act was passed and the policy for the abatement of pollution control was established. Supreme Court's guidelines for public interest litigation: no petition involving individual, personal matter shall be entertained as a PIL matter except as indicated hereinafter. Letter petitions falling under the following categories alone will ordinarily be entertained as public interest litigation. 1. Bonded labor matters. 2. Neglected children. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 12. Unit V Unit 7 Unit V. 3. Non-payment of minimum wages to workers and exploitation of casual workers and complaints of violation of labor laws, except in individual cases. 4. Petitions from jails complaining of harassment, for premature release, and seeking release after having completed 14 years in jail, death in jail, transfer, release on personal bond, speedy trial as a fundamental right. 5. Petitions against police for refusing to register a case, harassment by police and death in police custody. 6. Petitions against atrocities on women, in particular harassment of bride burning, rape, murder, kidnapping etc. 7. Petitions complaining of harassment or torture of villagers by co-villagers or by police from persons belonging to scheduled caste and scheduled tribes and economically backward classes. 8. Petitions pertaining to environmental pollution, disturbance of ecological balance, drugs, food adulteration, maintenance of heritage and culture, antiques, forest and wildlife and other matters of public importance. 9. Petitions from riot victims. 10. Family pension. Cases falling under the following categories will not be entertained as public interest litigation, and these may be returned to the petitioners or filed in the PIL cell, as the case may be. 1. Landlord-tenant matters. 2. Service matter and those pertaining to pension and gratuity. 3. Complaints against central, state government departments and local bodies except those relating to item nos. 1 to 10 above. 4. Admission to medical and other educational institution. 5. Petitions for early hearing of cases pending in high courts and subordinate courts. In regard to the petitions concerning maintenance of wife, children and parents, the petitioners may be asked to file a petition under Sec. 125 of Cr. PC or a suit in the court of competent jurisdiction and for that purpose to approach the nearest legal aid committee for legal aid and advice. Source: web links. Suo motu, action. Suo motu is a Latin term which means on its own motion. Suo motu, power allows the court to initiate legal action on their cognizance of a matter without any petition being filed, or interest being brought before them. Courts have initiated legal proceedings on their own based on media reports, telegrams and letters received by aggrieved people, taking a suo motu cognizance of the issue. One of the most prominent forms of India's suo motu power is to punish for contempt of court under Article 129 of the Constitution of India and the Contempt of Courts Act 1971. In 1994, a newspaper report on pollution in the Yamuna led the court to take up the issue suo motu. During COVID pandemic, a 3-judge bench of Honorable Supreme Court took suo motu cognizance of non-availability of midday meals for children due to the closure of schools due to coronavirus spread and issued notices to all state governments and union territories. The court noticed that non-supply of nutritional food to the children as well as lactating and nursing mothers may lead to large-scale malnourishment. Particularly, the children and the lactating and nursing mothers in rural as well as tribal area are prone to such malnourishment. Such malnutrition may affect their immunity system and as such children and lactating and nursing mothers would be more prone to catch the infection. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 13. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. In order to take control of the situation, the court, hence, issued directions to the competent authorities to do the needful. The court have increasingly used this power to intervene in instances of fundamental rights violations or to scrutinize government in action. D. Provision of legal aid. If a person belongs to the poor section of the society having annual income of less than Rs. 18,000, or belongs to scheduled caste or scheduled tribe, a victim of natural calamity, is a woman or a child or a mentally ill or otherwise disabled person or an industrial workman, or is in custody including custody in protective home, she is entitled to get free legal aid from the Supreme Court Legal Aid Committee. The aid so granted by the committee includes cost of preparation of the matter and all applications connected therewith, in addition to providing an advocate for preparing and arguing the case. Any person desirous of availing legal service through the committee has to make an application to the secretary and hand over all necessary documents concerning his case to it. The committee, after ascertaining the eligibility of the person, provides necessary legal aid to him, her. Persons belonging to middle income group, i.e. with income above Rs. 18,000, but under Rs. 120,000 per annum are eligible to get legal aid from the Supreme Court Middle Income Group Society, on nominal payments. A. Amicus Curie. Amicus Curiae, literally translated from Latin as friend of the court. If a petition is received from the jail or in any other criminal matter, if the accused is unrepresented, then an advocate is appointed as amicus curiae by the court to defend and argue the case of the accused. In civil matters also the court can appoint an advocate as amicus curiae if it thinks it necessary in case of an unrepresented party. The court can also appoint amicus curiae in any matter of general public importance or in which the interest of the public at large is involved. B. 2. E. High courts and lower courts. The high courts function as organs of judicial administration at the state level. Similarly, the lower courts function as centers of civil and criminal justice at the district level. Lower courts, as explained above, comprise of district and sub-ordinate courts. Districts courts are usually courts of first instance, where litigants proceed for their disputes. These courts have set territorial and pecuniary limits when accepting cases of civil nature. A similar hierarchy exists in the criminal courts at the sub-ordinate level. Once matters are adjudicated by these courts, they proceed to the high courts on appeal. Thus, sub-ordinate courts are mainly vested with the establishment of facts, while the appellate courts deal with interpretation of statutes, the correct application of law. The high courts have power to issue within their jurisdiction directions, orders, or writs, including writs which are in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari for enforcement of fundamental rights and for any other purpose. This writ jurisdiction is similar to the Supreme Court of India. The role of High Court also becomes similar to the Supreme Court in the exercise of public interest litigation. Furthermore, each High Court has powers of superintendence over all courts within its jurisdiction. It can call for records from such courts, make and issue general rules and prescribe forms to regulate their practice and proceedings and determine the manner and form in which book entries and accounts shall be kept. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 14. Unit V Unit 7 Unit V. Let us ponder what is a court of record? A court whose judgments and proceedings are kept on permanent record and that has the power to impose penalties for contempt. The Supreme Court and High Courts are called a court of record. As a court of record, the Supreme Court has two powers. The judgments, proceedings and acts of the Supreme Court are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any court. They are recognized as legal precedents and legal references. It has the power to punish for contempt of court, either with simple imprisonment for a term up to 6 months or with a fine or with both. As a court of record, the High Court has two powers. The judgments, proceedings and acts of the High Courts are recorded for perpetual memory and testimony. These records are admitted to be of evidentiary value and cannot be questioned when produced before any subordinate court. They are recognized as legal precedents and legal references. It has the power to punish for contempt of court, either with simple imprisonment or with a fine, or with both. Source: Web links, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 15. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. C. Appointments, retirement and removal of judges. CI Appointment of judges. Constitutional mandate. The method of appointment of judges at the Supreme Court, High Court and District Courts has been enshrined in the Constitution of India. According to Article 124 of the Constitution, every judge of the Supreme Court shall be appointed by the President after consultation with such of the judges of the Supreme Court and of the High Courts in the states, as the President may deem necessary. The article also provides that in case of appointment of a judge other than the Chief Justice of India, the Chief Justice must be consulted. The article further provides for the qualifications required to become a judge at the Supreme Court. These qualifications include citizenship of India and has been for at least 5 years a judge of a high court or of 2 or more high courts in succession, or has been for at least 10 years an advocate of a high court or of 2 or more such courts in succession, or is a distinguished jurist in the opinion of the President. Similarly, the procedure for appointment of judges at the High Court has been enshrined in Article 217 of the Constitution. This article prescribes that every judge of the High Court shall be appointed by the President after consultation with the Chief Justice of India, the Governor of the state. And in the case of appointment of a judge other than the Chief Justice of the High Court concerned. The qualifications of a High Court judge includes citizenship of India and has for at least 10 years held a judicial office in India, or has for at least 10 years been an advocate in a high court or of 2 or more such courts in succession. For the district and subordinate courts or the lower judiciary in India, the procedure for appointment is mentioned in Article 233 of the Constitution. Appointment of district judges in any state shall be made by the Governor of the state in consultation with the High Court exercising jurisdiction in relation to such state. The qualifications for appointment as district judge include member of judicial service of the state, or any person who has had a minimum of 7 years of practice as a lawyer at bar. CII. Current practice in the appointment of judges. Despite a clear constitutional mandate, the appointment of judges in practice remains a complex process. At present, the appointment at the Supreme Court and the High Court follows a collegium model, which is a judicial creation through case laws, even though not constitutionally mandated. The issue of appointment has often been linked to the independence of judiciary, and there has been a constant tussle between executive and judiciary over the appointment of judges. As early as the 14th Law Commission report under the chairmanship of M. C. Setalvad, India's first Attorney General in 1958, noted that the appointment or rejection of appointment of judges by the executive, in contrary to what the judiciary suggested, creating rather awkward situations. The report highlighted that several appointments were being made on political, regional, communal or other grounds, as a result of which the fittest of the lot were never appointed. The Commission thus suggested on strengthening the process of consultation between the executive and the judiciary. Later, a series of 3 judicial decisions, popularly known as the 3 judges cases, helped in the development of the modern collegium system. This development has been a result of a tumultuous Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 16. Unit V Unit 7 Unit V. Process, but in modern practice governs the rule for judicial appointments. The first judge's case, 1981, gave primacy to the executive and stated that the CJI's recommendation to the President can be refused for cogent reasons. It gave vast powers to the executive for the next 12 years, in making judicial appointments. This, however, was modified in the second judge's case, 1993. The judgment held that the Chief Justice of India has primacy in the matter of appointments to the Supreme Court and the High Courts, and that an appointment has to be in conformity with the final opinion of the Chief Justice of India, while emphasizing the desirability of consultation of the Chief Justice with other judges. The executive element in the appointment process was reduced to a minimum and political influence eliminated. This decision, rendered by a 9-judge bench, was however supported by only 5 judges on the bench, and the 4 other judges did not concur with the majority opinion. The years that followed thus witnessed some confusion in the process of appointment, as CJI made some unilateral appointments and the role of the President was reduced to a mere approval. Later in 1998, the Supreme Court, in a presidential reference, 1998 advisory decision, emphasized upon the role of consultation, and held that the process of appointment of judges to the Supreme Court and the High Courts is an integrated participatory consultative process. The Chief Justice of India firms up his opinion after consultation with a plurality of judges. His opinion is formed by a body of senior judges. A. The Collegium system for Supreme Court judges. Under the Collegium model for appointment of judges of the Supreme Court, the Chief Justice of India consults 4 senior-most judges of the Supreme Court. The Chief Justice of India sends his recommendations to the Union Minister of Law and Justice, who then puts up the same to the Prime Minister. The Prime Minister will then advise the President. B. The Collegium system for High Court judges. For High Courts, the Collegium comprises of the Chief Justice of the High Court and 2 senior-most judges of the High Court. The Chief Justice conveys his recommendations to the Chief Minister of the state and the Governor of the state, who in turn send their views directly to the Union Minister of Law and Justice. The complete material is then forwarded to the Chief Justice of India, who in consultation with a collegium of 2 judges of the Supreme Court, would send his recommendations to the Union Minister of Law and Justice. The Union Minister of Law and Justice then puts up the same to the Prime Minister, who will advise the President in the matter of appointment. Appointment of the Chief Justice of India. The Chief Justice of India is the senior-most judge of the Supreme Court. Seniority is determined on the basis of the date of their appointment to the Supreme Court, and if 2 judges are appointed to the court on the same day, the judge who takes the oath first is the senior judge. Seniority principle in appointment of CJI. According to this principle, the senior-most judge of the Supreme Court is appointed as the Chief Justice of India. The principle is an unwritten convention called the seniority principle in legal, academic and judicial parlance. It aims to safeguard the judiciary's independence from any sort of political interference. The Constitution of India under Article 124(2) grants power to the President of India to appoint in consultation with the outgoing Chief Justice, the next Chief Justice, who will serve until they reach the age of 65 or are removed by impeachment. As per convention, the name suggested by the incumbent Chief Justice is almost always the next senior-most judge in the Supreme Court. The suggestion is forwarded by the Union Law Minister to the Prime Minister, who then advises the President. Appointment of Chief Justice of High Courts. The Chief Justice of the High Court is appointed as per the policy of having Chief Justices from outside the respective states. The Collegium takes the call on the elevation. High Court judges are recommended by a Collegium comprising the CJI and 2 senior-most judges. The proposal, however, is initiated by the outgoing Chief Justice of the High Court concerned in consultation with 2 senior-most. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 17. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Colleagues. The recommendation is sent to the Chief Minister, who advises the Governor to send the proposal to the Union Law Minister. C. 2. Retirement and removal of judges in India. C. 2. I. Retirement of judges. The retirement age for a Supreme Court judge is 65 years. Similarly, a High Court judge continues in his office till the retirement age, which is 62 years. The age of retirement of District Court judges is determined by their respective state government under special service rules. The Venkatacharya Report, Report of the National Commission to Review the Working of the Constitution, 2002, recommended that the retirement age of the judges of the High Court should be increased to 65 years and that of the judges of the Supreme Court should be increased to 68 years. The Constitution, 114th Amendment, Bill was introduced in 2010 to increase the retirement age of High Court judges to 65. However, it was not taken up for consideration in Parliament and lapsed with the dissolution of the 15th Lok Sabha. The case in Western democracies. A retirement age of around 70 for judges is commonplace in most Western liberal democracies. Some of them even opt for 10 years for life. E.g., in the Supreme Court of the United States, and in constitutional courts in Austria and Greece, judges are appointed for life. In Belgium, Denmark, Ireland, the Netherlands, Norway and Australia, the retirement age for judges is 70 years. Rationale behind suggesting for the increasing the retirement age of judges in India. The judge population ratio in India is among the lowest in the world. It is also necessary to increase the number of judges in the pool to enable the judiciary to deal with the enormous pendency of cases. Moreover, legislations provide for retired High Court and Supreme Court judges to man tribunals till the age of 70 as chairmen and 65 as members. There is no reason why these judges should be retired so early. One aspect which has not been factored in is that as the Indian economy grows, the ratio of litigation to population will increase exponentially. Advanced economies such as Australia, Canada, France, the US, the UK, and Japan have much higher litigation to population ratios. Several senior lawyers with requisite expertise and experience declined to accept judgeship due to the lower retirement age of 62, especially in the high courts. By an enhanced age, this problem could be rectified as advocates would have greater incentive to forego their individual legal practice and function in the role of judges. Further, the relatively early retirement age in India is often linked to the declining quality of judicial service and the inability of a judge to properly effectuate the stipulated judicial workload. Positive consequences: this will have significant benefits. Senior serving judges will bring with them years of experience. It will ensure the continued presence of a strong talent pool of experienced judges. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 18. Unit V Unit 7 Unit V. New judges can be appointed without displacing existing judges. It will address the problem of mounting arrears. It will be a buffer against impending litigation explosion. It will render post-retirement assignments unattractive and, as a consequence, strengthen the rule of law and the independence of the judiciary, both of which are crucial to sustain democracy. Way forward, India faces the perennial issue of backlog of cases. Increasing the age of judges will certainly help in addressing this issue. The retirement age of judges of the Supreme Court and High Courts could be increased, but with the option of quitting before reaching the age of superannuation, a practice prevailing in Zimbabwe, where a top court judge is appointed to retire at 65 years but can opt to continue till 70. Moreover, merely increasing the retirement age of the judges is not a solution for problems in Indian judiciary. Other issues like lack of transparency, particularly in the appointment of judges, under trials of the accused, lack of information and interaction among people and courts must also be addressed. Fill in the blanks. 1. The judges of the High Court are appointed by the Governor, President, Prime Minister. 2. At present there are High Courts in India. 20, 21, 18. 3. The retirement age of the judges of a High Court is years 60, 65, 62. C. 2. E. Removal of judges. Judges of the Supreme Court and the High Courts can be removed through a process called as impeachment. The process for removal of the judges is the same for both the Supreme Court and the High Courts. Article 124(4) enshrines the guidelines for the removal of a sitting Supreme Court judge. The procedure for removal of the Supreme Court judge is guided by Article 124(4) of the Constitution of India and the Judges' Inquiry Act, 1968. Article 218 of the Constitution of India provides for the impeachment of High Court judges. The judges can be removed on two grounds: I. Incapacity and E. Proven misbehavior. The procedure is explained below. Step 1. Notice of motion for removal of a judge. Removal proceedings against a Supreme Court or a High Court judge can be initiated in any of the Houses of Parliament. For this, 1. A minimum of 100 members of Lok Sabha may give a signed notice to the Speaker, or 2. A minimum of 50 members of Rajya Sabha may give a signed notice to the Chairman. The Speaker or Chairman may consult individuals and examine relevant content related to notice, and according to that, he or she may decide to either admit or refuse to admit it. Step 2. Constitution of an inquiry committee. After the motion is admitted, the Speaker of the Lok Sabha or Chairman of the Rajya Sabha will form an inquiry committee as per Article 3(2) of the Judges' Inquiry Act, 1968 to start investigating the Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 19. UNITI. Unit 2. Unit 3. Unit IV. UNITV. Unit V. Unit 7. Unit V. Complaint. It will consist of the following members: a Supreme Court judge, a High Court Chief Justice, and a distinguished jurist, as per the opinion of the Speaker, Chairman. If such notices have been admitted in both the Houses of Parliament, the inquiry committee will be formed together by the Speaker and the Chairman of the respective Houses. In this scenario, the notice that has been on a later date will stand rejected. If such notices have been passed by both the Houses of Parliament on the same day, the inquiry committee will not be formed. Step 3. Submission of the inquiry report. After concluding its investigation, the inquiry committee will put down its findings in a formal report and submit it to the Speaker or Chairman. If the report finds misbehavior or incapacity which makes the judge guilty, the motion for removal has to be put to vote in both the Lok Sabha and Rajya Sabha. As per Article 124(4) of the Constitution, the motion is required to be adopted in each House by a majority of the total membership of the House, and a majority of not less than 2/3 of members present and voting. If the motion is adopted by this majority in one House, the motion will be sent to the other House. Step 4. Order by the President. As per Article 124(4), after the motion is adopted in both the Houses by the required majority, it is placed before the President of India, who will issue an order for the removal of the judge. Removal of judges at district level. As to the removal of judges in the lower judiciary, a district judge or an additional district judge can be removed from his office by the state government in consultation with the High Court. Number of times impeachment proceedings were initiated against a SC or HC judge. Impeachment proceedings against SC or HC judges initiated a total of 5 times in Indian history. 1. V. Ramaswamy J. was the first judge against whom impeachment proceedings were initiated. In 1993, the motion was brought up in Lok Sabha but failed to secure the required 2/3 majority. 2. Soumitra Sen J. of the Calcutta High Court resigned in 2011 after the Rajya Sabha passed an impeachment motion against him. He was the first judge to have been impeached by the upper house for misconduct. 3. In 2015, 58 members of the Rajya Sabha moved an impeachment notice against J.B. Pardiwala J. of the Gujarat High Court for his objectionable remarks on the issue of reservation. 4. In 2017, Rajya Sabha MPs moved a motion to initiate impeachment proceedings against C.V. Nagarjun Reddy J. of the High Court for Andhra Pradesh and Telangana. 5. In March 2018, opposition parties signed a draft proposal for moving an impeachment motion against Deepak Misra CJI. 6. Amidst charges of corruption, land grab, and abuse of judicial office, P.D. Dinakaranja, Chief Justice of the Sikkim High Court, against whom the Rajya Sabha chairman had set up a judicial panel to look into allegations of corruption, resigned in July 2011, before impeachment proceedings could be initiated against him. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 20. Unit V Unit 7 Unit V. D. Tribunals. What are tribunals? Tribunals are semi-judicial bodies involved in dispute resolution. They function as semi- or quasi-judicial bodies as they consist of administrative officers or judges without a legal background. Yet they function in their judicial capacity and hear relevant legal matters and settle claims between the parties. They complement and supplement the role of courts in maintaining law and justice in the society. Tribunals were not part of the original constitution. It was incorporated in the Indian Constitution by 42nd Amendment Act, 1976. Article 323A deals with administrative tribunals and Article 323B deals with tribunals for other matters. Thus the 42nd Amendment Act ushered the era of tribunalization of Indian judiciary. Further, the enactment of Administrative Tribunals Act, 1985 took the constitutional objective further and set up the Central Administrative Tribunal, CAT, and State Administrative Tribunals. The CAT was set up pursuant to the Act of the Legislature in 1985. The tribunals exercise jurisdiction of service matters of employees covered by it. The appeals against the orders of the administrative tribunals lie before the division bench of the concerned High Court. Under Article 323B, the Parliament and the state legislatures are authorized to provide for the establishment of tribunals for the adjudication of disputes relating to the following matters: taxation, foreign exchange and export, industrial and labor disputes, land reforms laws, ceiling on urban property, elections, disputes of members of parliament and state legislatures, production, procurement, supply and distribution of foodstuffs and essential goods, rent and tenancy issues. Articles 323A and 323B differ in the following three aspects. While Article 323A contemplates the establishment of tribunals for public service matters only, Article 323B contemplates the establishment of tribunals for certain other matters, mentioned above. While tribunals under Article 323A can be established only by Parliament, tribunals under Article 323B can be established both by Parliament and state legislatures with respect to matters falling within their legislative competence. The tribunals are procedurally flexible and this flexibility increases their efficiency. For example, the Administrative Tribunals Act, 1985 allows the aggrieved persons to appear directly before the tribunals. The overall objectives of the tribunals are to provide speedy and inexpensive justice to the litigants. Since government is a major litigant in the courts and government-related litigation has increased in the delay and pendency of litigation, such tribunals over the past 2 decades have significantly contributed in supplementing the role of the courts in adjudication of service disputes. The tribunals, however, are not meant to replace the courts. This has been explained by the 7-judge bench of the Supreme Court in L. Chandrakumar case, IT 1997, 3, South Carolina 589, where it was held that tribunals would not take away the exclusive jurisdiction of the courts, and their decisions could be scrutinized by the division bench of the high courts. Tribunals have been constituted under specific constitutional mandate enshrined in The Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 21. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Constitution of India or through legal enactments, e.g. a law passed by the legislature. Their creation aims at increasing efficiency in resolving disputes and reducing the burden on courts. Examples of some of these tribunals include Central Administrative Tribunal, CAT, for resolving the grievances and disputes of central government employees, and State Administrative Tribunals, SAT, for state government employees. Telecom Dispute Settlement Appellate Tribunal, TDSAT, for resolving disputes in the telecom sector in India. And the National Green Tribunal, NGT, for disputes involving environmental issues. Some of these tribunals function with regulators. Regulators are specialized government agencies that oversee the law and order compliance in the relevant government sectors. For example, one of the tribunals TDSAT functions alongside the regulator, TRAI, Telecom Regulatory Authority of India, in formulating laws and policy for resolving telecom disputes in India. Did you know? There are 19 benches and 19 circuit benches in the Central Administrative Tribunal all over India. The Government of India has notified 215 organizations including ministries and departments of central government, under Section 14(2) of the Administrative Tribunals Act, 1985 to bring them within the jurisdiction of the Central Administrative Tribunal, from time to time. In addition, the Central Administrative Tribunal, principal bench is dealing with the matters of government of National Capital Territory of Delhi. The tribunal consists of a chairman, vice chairman and members. The members of the tribunal are drawn both from judicial as well as administrative streams so as to give the tribunal the benefit of expertise both in legal and administrative spheres. Source: Web links. id = 36. A. Courts and judicial review. The powers of judicial review allow judiciary to safeguard the checks and balances and to ensure the separation of powers of the other two branches of the government. Courts have judicial review powers to declare any law as unconstitutional if it is enacted by breaching the demarcation. This concept dates back to 1800 and the landmark case of Madison v. Marbury. Justice Williams applied this principle for the first time and later became one of the most important judicial principles. Madison v. Marbury. Facts of the case. Thomas Jefferson defeated John Adams in the 1800 presidential election. Before Jefferson took office on March 4, 1801, Adams and Congress passed the Judiciary Act of 1801, which created new courts, added judges, and gave the president more control over appointment of judges. The act was essentially an attempt by Adams and his party to frustrate his successor, as he used the act to appoint 16 new circuit judges and 42 new justices of the peace. The appointees were approved by the Senate, but they would not be valid until their commissions were delivered by the Secretary of State. William Marbury had been appointed Justice of the Peace in the District of Columbia, but his commission was not delivered. Marbury petitioned the Supreme Court to compel the new Secretary of State, James Madison, to deliver the documents. Marbury, joined by 3 other similarly situated appointees, petitioned for a writ of mandamus compelling the delivery of the commissions. Question. 1. Do the plaintiffs have a right to receive their commissions? Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 22. Unit V Unit 7 Unit V. 2. Can they sue for their commissions in court? 3. Does the Supreme Court have the authority to order the delivery of their commissions? Conclusion. The court found that Madison's refusal to deliver the commission was illegal, but did not order Madison to hand over Marbury's commission via writ of mandamus. Instead, the court held that the provision of the Judiciary Act of 1789 enabling Marbury to bring his claim to the Supreme Court was itself unconstitutional, since it purported to extend the court's original jurisdiction beyond that which Article 3, Section 2, established. Marshall expanded that a writ of mandamus was the proper way to seek a remedy, but concluded the court could not issue it. Marshall reasoned that the Judiciary Act of 1789 conflicted with the Constitution. Congress did not have power to modify the Constitution through regular legislation because Supremacy Clause places the Constitution before the laws. In so holding, Marshall established the principle of judicial review, i.e., the power to declare a law unconstitutional. Source: Web links. Meaning, judicial review is a principle or a legal doctrine or a practice whereby a court can examine or review an executive or a legislative act, such as law or some other governmental or administrative decision, and determine if the act is incompatible with the Constitution. In some countries, like the United States, France and Canada, judicial review allows the court to invalidate or nullify the law or the act of the legislature or the executive if they are found to be contrary to the Constitution. In the United Kingdom, judicial review powers are restricted. The courts do not have authority to nullify or invalidate legislation of the Parliament. Likewise, there may be other countries where courts may have different kind of restrictions and may review only one branch. India, which is based on the parliamentary form of government, follows the system of separation of powers among the three branches of the government as prescribed in the Indian Constitution. The executive branch consists of the President, the Prime Minister and the bureaucracy. The legislative branch includes both houses of parliament, the Lok Sabha and the Rajya Sabha. In the judiciary, the Supreme Court is the final authority for interpreting the Constitution. Judiciary is quite independent of the other two branches. Constitution provides checks and balances so that no one branch exercises its supremacy over the others or misuse the powers provided to them. In this way, each branch puts a check on the other whenever there is an encroachment or conflict of powers among them and thereby preventing any concentration of powers in one branch. A. 1. Doctrine of basic structure. The doctrine of basic structure is an evolution of judiciary and has been regarded as an important element of judicial review. Basic structure doctrine invalidates any constitutional amendments that destroys or harms the basic or essential feature of the Constitution, like secularism, democracy and federalism. Supreme Court has also held judicial review to be the basic structure or feature of the Constitution. As a result, it can nullify any constitutional amendment that abolishes or disregards judicial review in issues concerning to fundamental rights of citizens. This concept was introduced by judiciary in order to tide over the spate of amendments which were eroding into the basic elements of the Indian Constitution. This doctrine comes into play when it is felt that the executive and legislature transgress the boundary defined by the Constitution underlying the spirit of separation of powers. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 23. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. A. 1. I. Evolution of the basic structure concept. The concept of the basic structure of the Constitution evolved over time. We shall discuss the evolution of the concept with the help of some landmark judgment related to this doctrine. Shankari Prasad Case, 1951. In this case, the SC contended that the Parliament's power of amending the Constitution under Article 368 included the power to amend the fundamental rights guaranteed in Part 3 as well. Goleknath case, 1967. In this case, the court reversed its earlier stance that the fundamental rights can be amended. It said that fundamental rights are not amenable to the parliamentary restriction as stated in Article 13 and that to amend the fundamental rights a new constituent assembly would be required. Also stated that Article 368 gives the procedure to amend the Constitution but does not confer on Parliament the power to amend the Constitution. This case conferred upon fundamental rights a transcendental position. The majority judgment called upon the concept of implied limitations on the power of the Parliament to amend the Constitution. As per this view, the Constitution gives a place of permanence to the fundamental freedoms of the citizens. In giving to themselves the Constitution, the people had reserved these rights for themselves. Kesavananda Bharti case, 1973. This was a landmark case in defining the concept of the basic structure doctrine. The SC held that although no part of the Constitution, including fundamental rights, was beyond the Parliament's amending power, the basic structure of the Constitution could not be abrogated even by a constitutional amendment. The judgment implied that the Parliament can only amend the Constitution and not rewrite it. The power to amend is not a power to destroy. This is the basis in Indian law in which the judiciary can strike down any amendment passed by Parliament that is in conflict with the basic structure of the Constitution. Indira Nehru Gandhi v. Rajnarain case, 1975. Here, the SC applied the theory of basic structure and struck down Clause 4 of Article 329A, which was inserted by the 39th Amendment in 1975 on the grounds that it was beyond the Parliament's amending power as it destroyed the Constitution's basic features. The 39th Amendment Act was passed by the Parliament during the emergency period. This act placed the election of the President, the Vice President, the Prime Minister and the Speaker of the Lok Sabha beyond the scrutiny of the judiciary. The 39th Amendment was upheld by 4 of the 5 judges on the bench, but only after they overturned the portion of the amendment that aimed to limit the judiciary's ability to rule in the present election dispute. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 24. Unit V Unit 7 Unit V. Manorwa Mills case, 1980. This case again strengthens the basic structure doctrine. The judgment struck down 2 changes made to the Constitution by the 42nd Amendment Act 1976, declaring them to be violative of the basic structure. The judgment makes it clear that the Constitution, and not the Parliament, is supreme. In this case, the court added 2 features to the list of basic structure features. They were judicial review and balance between fundamental rights and DPSP. The judges ruled that a limited amending power itself is a basic feature of the Constitution. Indira Sawhney and Union of India, 1992, SC examined the scope and extent of Article 16(4), which provides for the reservation of jobs in favor of backward classes. It upheld the constitutional validity of 27% reservation for the OBCs with certain conditions, like creamy layer exclusion, no reservation in promotion, total reserved quota should not exceed 50%, etc. Here, rule of law was added to the list of basic features of the Constitution. S.R. Bommai case, 1994. In this judgment, the SC tried to curb the blatant misuse of Article 356, regarding the imposition of President's rule on states. In this case, there was no question of constitutional amendment, but even so, the concept of basic doctrine was applied. The Supreme Court held that policies of a state government directed against an element of the basic structure of the Constitution would be a valid ground for the exercise of the central power under Article 356. It can be concluded that the Supreme Court's judgments frequently mention the sovereign, democratic, and secular nature of the rule of law, the judiciary's independence, fundamental rights of citizens, etc., as crucial components of the Constitution. One certainty that emerged out of this tussle between Parliament and the judiciary is that all legislations and constitutional amendments are now subject to judicial review, and laws that violate the fundamental framework are likely to be overturned by the Supreme Court. In essence, Parliament's ability to alter the Constitution is limited, and all constitutional amendments are ultimately decided upon, scrutinized and interpreted by the Supreme Court. Thus, after the decisions of the Supreme Court in Kesavananda Bharati case, Indira Gandhi election case and Manerva Mills case, it can be concluded that the Parliament's power to amend the Constitution is limited, and in the exercise of its constituent power, the Parliament cannot violate the basic structure of the Constitution. A. 2. Scope of judicial review in India. Judicial review is one of the essential features of the Indian Constitution. It has helped preserve the constitutional principles and values and the constitutional supremacy. The power of judicial review is available to the Supreme Court and the High Courts in different states in the matters of both legislative and administrative actions. With respect to judicial review on matters of executive or administrative actions, courts have employed doctrines such as proportionality, legitimate expectation, reasonableness, and the principles of natural justice. Essentially, the scope of judicial review in courts in India has developed with respect to three issues. 1. Protection of fundamental rights as guaranteed in the Constitution. 2. Matters concerning the legislative competence between the centre and states. And 3. Fairness in executive acts. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 25. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. 1. Individual and Group Rights. Article 13, 2, of the Constitution of India provides that the state shall not make any law which takes away or abridges the rights conferred by this part, Part 3, Fundamental Rights, and any law made in contravention of this clause shall, to the extent of the contravention, be void. B. R. Ambedkar, the chairman of the Constitution Drafting Committee of the Constituent Assembly, has termed this provision as the heart of the Constitution. This article provides explicitly the powers of judicial review to the courts in the matters of fundamental rights. Furthermore, Article 32 offers the Supreme Court the power to enforce fundamental rights, and provides 1. The right to move the Supreme Court for the enforcement of those rights. From this article, the Supreme Court derives authority to issue directions or order or writs in the nature of 1. Habeas corpus, i.e., to order the release of person is unlawfully detained. 2. Mandamus, i.e., to order to a public authority to do its duty. 3. Prohibition, i.e., to prevent a subordinate court from continuing on a case. 4. Quo warranto, i.e., to issue directive to a person to vacate an office wrongfully occupied. And 5. Certiorari, i.e., to remove a case from a subordinate court and get the proceedings before it. Like Article 32, Article 226 has a parallel provision for high courts in states and allows one to institute similar writs in the high courts for the enforcement of fundamental rights. Courts, through its judicial review practice, have liberalized the doctrine of locus standi, right to appear before or petition the court, for the enforcement of fundamental rights of those who lack access to courts due to the reasons of poverty or social and economic disabilities. This method led to the development of public or social action litigation, PIL or SAL, whereby any public-spirited person can petition or write letters to courts on behalf of the human rights violation victims or aggrieved parties. 2. Center-state relations. Judicial review has also been used in matters concerning the legislative competence with regards to the center-state relations. Article 246 of the Constitution provides that the Parliament has exclusive powers to make laws with respect to matters itemized in the Union List, List 1 of the 7th Schedule of the Constitution. It provides further that both the Parliament and the legislature of any state have powers to make laws with respect to matters enumerated in the concurrent list, List 3 of the 7th Schedule of the Constitution. With respect to the states, it provides that the legislature of any state has exclusive power to make laws with respect to matters listed in the State List, List 2 of the 7th Schedule. This article delivers clear division of law-making powers, division of powers, as well as room for intersection between the center and the state. Judicial review helps demarcate the legislative competencies and ensures that center does not exert its supremacy over the state matters and likewise states do not encroach upon matters within the ambit of the center. 3. Fairness in executive actions. In matters of executive or administrative actions, judicial review practice of courts have often employed doctrines like principles of natural justice, reasonableness, proportionality, and legitimate expectation. Discussed below are few examples. There is a Latin phrase audi alteram partem, which literally means, listen to the other side. This phrase is an established principle in the Indian law practice and was applied by the Supreme Court in several cases including the landmark decision of Maneka Gandhi v. Union of India. Her passport was confiscated by the governmental authorities without giving her any chance of prior hearing. Invoking its judicial review powers in administrative matters, the Supreme Court held that in the matter of confiscation of passport a hearing should have been given to Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 26. Unit V Unit 7 Unit V. The petitioner in the interest of the principles of natural justice. Consequently, a hearing was given and the passport was returned to her. This is an example where the court adopted the principle of post-decision hearing, in situations of urgency where prior hearing is not feasible, and recognized that a chance of hearing cannot be debarred completely. To conclude, judiciary in India enjoys a very significant position since it has been made the guardian and custodian of the Constitution. It not only is a watchdog against violation of fundamental rights guaranteed under the Constitution and thus insulates all persons, Indians and aliens alike, against discrimination, abuse of state power, arbitrariness etc. But borrowing the words of one of the founding fathers of the American Constitution, James Madison, I would say that the judiciary in India is truly the only defensive armor of the country and its constitution and laws. If this armor were to be stripped of its onerous functions, it would mean the door is wide open for nullification, anarchy and convulsion. Exercise 1. Besides being an adjudicator and an interpreter, the Supreme Court performs another function under Article 143 of the Indian Constitution. Identify and explain this function of the Supreme Court of India. 2. The power of judicial review is available to the Supreme Court and High Courts of states in the matters of both administrative and legislative actions. How far has the judicial review principle been successful in ensuring the fairness in executive actions? Discuss by referring to a decided case law. 3. Can impeachment proceedings be initiated against this sitting judge? If yes, explain the grounds and procedure for impeachment. How many times has this process been successful in the history of Indian judiciary? 4. What are tribunals? How do they play an instrumental role in rendering more effective dispute resolution mechanism? 5. Elucidate on the current practice for the appointment of members of higher judiciary in India. 6. List any two constitutional officers endowed with the function to advise and represent the government on legal matters. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 27. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Supplementary reading material. Case 1. HUSSAINARA Khatun vs State of Bihar. Background. A well-known landmark judgment case which gave wider interpretation of Article 21 and held that speedy trial is the fundamental right of every citizen. This landmark case emphasized upon speedy trial and free legal aid for the effective administration of justice and equality among the citizens. Article 21 of the Indian Constitution states that, no person shall be bereft of his life and personal liberty except according to the procedure established by law. Within the absence of speedy trial, justice can't be administered. Facts of the case. A writ petition habeas corpus was filed before the court under Article 32 of the Indian Constitution. This writ petition was also filed before the court because it was for the release of 17 under trial prisoners. It depicted a sorrowful picture of the administration of justice within the state of Bihar. An outsized number of persons, which even included mainly the categories like women, children, and other deprived categories of poor section, and that they all were locked behind the bars and were seeking for the trial as well as their release. Thus, the state of Bihar was advised to file a revised chart which was focused and clearly mentions the year-wise break from the under-trial prisoners after segregating the prisoners into two categories, that is, ones charged with minor offences and others who have been charged with major offences, but although this direction was not carried by the state. The petition acknowledged that the under-trial prisoners who have done minor offences, as they were imprisoned for quite 10 years. Those people were considered to the poorest strata who weren't even able to afford an advocate, and also, they were refused to grant bail. Issues raised are. The issues raised in this case were: 1. Whether the supply of free legal aid be enforced by law. 2. Whether right to speedy trial come within the ambit of Article 21. 3. What's the essence of speedy trial under criminal justice? Provisions. Article 21 of the Indian Constitution, Article 39A of the Indian Constitution, contentions of counsels of both the parties. In the counter affidavit, the respondents submitted that many under trial prisoners, petitioners etc. herein confined within the Patna Central Jail, Muzaffarpur Central Jail and Ranchi Central Jail, as they need been produced before the magistrate and were given judicial custody again and again. However, the Honorable Court didn't find this averment to be true on the respondents who were not able to produce or present those dates on which these under trial prisoners who were made to be remanded. To justify the increasing number of pending cases, many arguments and counter questions were raised before the Honorable Court. Respondents contended that it mainly occurred due to the happening of delay in receipt of opinions from the experts. There occurs delay in receipt of opinions from the experts. The court rejected this contention because state can always introduce and amend new and best alternative methods for the effective administration of justice. The opposite reason of their contention was their poverty, due to that they could not even seek for their bail, just like the rich men in the society. However, the Honorable Court rejected the contentions on the grounds that state can employ alternative methods for the identical judgment. The court observed the above case and also directed that the under trial prisoners whose name and Textbook of Legal Studies XII 2023-2024 www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 28. Unit V Unit 7 Unit V. Particulars were filed by Mrs. Hingorani should be released. It had been because imprisonment like false imprisonment were considered to be an illegal and also violative of their fundamental rights enshrined under Article 21 of the Indian Constitution. The court also mandated that in the time of charging bailable offences, they need to be produced before the magistrate on remand dates. The government ought to name a legal advisor at their own expenses for making an application for bail. A quick trial is much required for securing justice. The court also ordered both the government as well as High Court to display the particulars regarding the location of the courts of magistrate and court of sessions in the state of Bihar along with the cases pending in each court on the 31st of December 1978. They were also asked to state the rationale of pendency of cases. On next remand dates, the under trial prisoners should be produced before the court in order that the state government ought to designate a lawyer of its own expense. The state cannot avoid its constitutional obligation to supply speedy trial to the accused by the way of pleading. Free legal service to the poor and therefore the needy people is an essential elementary factor of legal aid. Another direction by the Honorable Court was to supply the under trial prisoners charged with bailable offences, free legal aid by the state, on their next remanded dates before the magistrates. The court further observed that detaining them for any long would be illegal and is clearly against the elemental rights under Article 21 as these prisoners are behind the bars. Although nowadays human rights are being demanded for everyone in this world, but are these under trial prisoners not to be protected from such harm or even torture? In fact, they too are human rights, hence their rights must not be denied. Equal access to justice must be central point which has to be given due recognition. Rationale behind the judgment. As per Article 21 of the Indian Constitution states that, no person shall be bereft of his life or liberty except in accordance with the procedure established by law which ought to be reasonable, fair and just. Here the state cannot deny the constitutional rights, even all the humans do have their own human rights to be preserved. Article 39A may be a constitutional directive that stress upon free legal service. It's depicted as an inalienable element regarding reasonable, just and fair procedure. Within the absence of, it will result in denial of justice among the poor sections of the society. The court realized the plight of under trial prisoners whose denial of rights. Court gave stress upon unable to interact a lawyer and disregarding human rights were the main issues which have focused and also to be solved. The court realized the denial and disregarding nature of private liberty. The court also found that the under trial prisoners of whose list which was filed before the court, they need been in jail for a longer period. Even the period of time was too long enough than the prescribed time range that they could have been sentenced to jail if convicted. The court recommend the state also as central government, by directing them to list out the entire number of cases, location of courts of magistrates and courts of session. Mainly the articles include Article 14, Article 39A and Article 21. Honorable Supreme Court of India held that the state cannot deny the constitutional right of speedy trial and equal access to justice shouldn't be denied on any grounds. This case motivated various lawyers to boost their voice against the denial of rights which are fundamental in nature. Case analysis. As per Article 21, speedy trial is taken into account as fundamental right and basic right. Although the Article 3 of European Convention on Human Rights also provides that a person arrested and detained shall be entitled to a trial within a reasonable period. Speedy trial is constitutionally guaranteed right when it involves United States also. Just locking them behind the bar wouldn't serve justice. During this current scenario, human rights have to be given primarily importance. But the rights available to prisoners are denied. It must even be ensured at right time. By the way of amendment procedures and also mentioning of an effective judiciary, justice are often served at the utmost level. Conclusion. Justice served for several under trial prisoners and who were released after this judgment. Even the importance of public interest litigation, PIL, was also highlighted and got priority. Lawyers, scholars and other legal authorities expanded the scope of PIL. Voices were raised against the deprived categories of the society. It's very much possible that these prisoners may be acquitted or be imprisoned for a lesser time period, but all this is only possible if they are subjected to free legal. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 29. UNITI. Unit 2. Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Aid. Just locking them behind the bars would no serve any justice to them. These prisoners too are humans, and now the government as well as judiciary should realize and recognize their rights. Hence the petitions served their purposes and stand disposed of leaving the further implementations to the Supreme Court. Source: Web links. Case 2. Menka Gandhi v. Union of India. Case summary. Menka Gandhi, petitioners, v. Union of India, respondents. The landmark ruling in Menka Gandhi vs. Union of India, which stands as a bulwark of the right of personal liberty granted by Article 21 of the Constitution, started when the passport of the petitioner in this case was impounded by the authorities under the provisions of the Passport Act. This arbitrary act of impounding the passport eventually led to the pronouncement of a unanimous decision by a 7-judge bench of the Apex Court comprising M.H. Beg, C.J.I., Y.V. Chandrachud, V.R. Krishnaiyer, P.N. Bhagwati, N.L. Utwalia, S. Murtaza Fazal Ali and P. S. Kalasam. Brief facts. The petitioner Menka Gandhi's passport was issued on the 1st of June 1976 as per the Passport Act of 1967. On the 2nd of July 1977, the Regional Passport Office, New Delhi, ordered her to surrender her passport. The petitioner was also not given any reason for this arbitrary and unilateral decision of the External Affairs Ministry, citing public interest. The petitioner approached the Supreme Court by invoking its writ jurisdiction and contending that the state's act of impounding her passport was a direct assault on her right of personal liberty as guaranteed by Article 21. It is pertinent to mention that the Supreme Court in Satwant Singh Soni v. Ramaratnam held that right to travel abroad is well within the ambit of Article 21, although the extent to which the Passport Act diluted this particular right was unclear. Issues before the court. Are the provisions under Articles 21, 14 and 19 connected with each other, or are they mutually exclusive? Should the procedure established by law be tested for reasonability, which in this case was the procedure laid down by the Passport Act of 1967? If the right to travel outside the country is a part of Article 21 or not? Is a legislative law that snatches away the right to life reasonable? Arguments of the petitioners. Through the administrative order that seized the passport on the 4th of July 1977, the state has infringed upon the petitioners' fundamental rights of freedom of speech and expression, right to life and personal liberty, right to travel abroad and the right to freedom of movement. The provisions given in Articles 14, 19 and 21 should be read together and aren't mutually exclusive. Only a cumulative reading and subsequent interpretation will lead to the observance of principles of natural justice and the true spirit of constitutionalism. India might not have adopted the American concept of the due process of law; nevertheless, the procedure established by law should be fair and just, reasonable, and not be arbitrary. Section 10(3)(c) of the Passport Act violates Article 21 insofar as it violates the right to life and personal liberty guaranteed by this article. Audi alteram partem, i.e., the opportunity of being heard, is invariably acknowledged as a vital component of the principles of natural justice. Even if these principles of natural justice are not expressly mentioned in any of the provisions of the Constitution, the idea behind the spirit of Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. UNITI. Unit 2. Unit 3 Unit IV. UNITV. 30. Unit V Unit 7 Unit V. Fundamental rights embodies the very crux of these principles. Contentions of the respondents. The respondent stated before the court that the passport was confiscated since the petitioner had to appear before a government committee for a hearing. The respondent asserted that the word law under Article 21 can't be understood as reflected in the fundamental rules of natural justice, emphasizing the principle laid down in the A.K. Gopalan case. Article 21 contains the phrase, procedure established by law, and such procedure does not have to pass the test of reasonability and need not necessarily be in consonance with the Articles 14 and 19. The framers of our Constitution had long debates on the American due process of law versus the British procedure established by law. The marked absence of the due process of law from the provisions of the Indian Constitution clearly indicates the Constitution makers' intentions. Judgment. This immensely important judgment was delivered on the 25th of January 1978, and it altered the landscape of the Indian Constitution. This judgment widened Article 21's scope immensely, and it realized the goal of making India a welfare state, as assured in the preamble. The unanimous judgment was given by a 7-judge bench. The Supreme Court held that the scope of personal liberty given under Article 21 of the Constitution of India is very wide. The right to travel abroad comes with the definition of personal liberty given under Article 21. However, the court agreed that impounding the passport by the passport authorities under Section 10(3) of the Passport Act is not unconstitutional because the passport authority has the power to grant suspension and cancel the passport, which can be important for national security. But, here, in this case, Menka Gandhi was not given an opportunity of being heard, and no valid reasons for impounding her passport were given to her by the passport authority. The maxim of audi alteram partem, which means let the other side be heard, was not followed in this case. Menka Gandhi was allowed post-decisional hearing. Moreover, the Supreme Court stated that Article 14, right to equality, Article 19, right to freedom, and Article 21, right to life and personal liberty, form the golden triangle of the Constitution. At any time, if a law deprives a person of his personal liberty, it has to meet the criteria as specified in Article 14 and Article 19. Therefore, the passport authority can impound the passport of any citizen only after giving valid reasons for the same. Effects of the Menka Gandhi judgment. After this judgment, the doctrine of post-decisional theory was evolved. The court also ruled that the mere existence of law is not enough. Such law should also be just, fair and reasonable. So, a liberal interpretation given by the court for Article 21 results in making procedure established by law, along with due process of law. Procedure established by law means that any law made by the legislature or any such body will be valid only if the correct procedure has been followed while making the law. Due process of law means that a government must protect and respect the legal rights of an individual. Adapted from India Kanun. Writing Law. Com. Legal Services in Ed. Com. Unit 2. Alternative Dispute Resolution in India, ADR. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 33. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Alternative Dispute Resolution in India, ADR. Learning outcomes. Students will be able to analyze and compare the adversarial and inquisitorial systems of justice dispensation, explain the meaning and scope of ADR, evaluate the benefits of ADR. Identify and explain the various types of ADR: arbitration, mediation, conciliation, Lok Adalat and tribunals. Evaluate and explain the role of various ombudsman CVC, Lokpal and Lokayukt, banking ombudsman and insurance ombudsman. I. Adversarial and inquisitorial systems. Every legal system in this world can be broadly classified into two models, adversarial and inquisitorial. Both the systems aim at dispensing justice, but they differ in their techniques of adjudication and justice delivery mechanisms. Therefore, this classification becomes important. Let us understand the meaning of each of the systems and the main differences between them. In an adversarial system, the parties in a legal proceeding develop their own theory of the case and gather evidence to support their claims. The parties are assisted by their lawyers who take a proactive role in delivering justice to the litigants. The lawyers gather evidence and even participate in cross-examination and scrutiny of evidence presented by the other disputing party. The role of the judge, decision maker, is rather passive, as the judge decides the claims based solely on the evidence and arguments presented by the parties and their lawyers. In an inquisitorial system, the judge, decision maker, takes a center stage in dispensing justice. The role of the judge, decision maker, is active as she determines the facts and issues in dispute. Unit 2. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 34. Unit V Unit 7 Unit V. The judge, decision maker, also decides the manner in which the evidence must be presented before the court. For example, the judge may decide for presentation of a specific form of evidence, i.e. oral, witness statement, or documentary, correspondence between the parties through letters, emails, or a combination of both. The judge then evaluates the evidence presented before him, her, and decides upon the legal claims. Therefore, this model of adjudication is also known as the interventionist, investigative model. Furthermore, in such a system, less reliance is placed on cross-examination and other techniques often used by lawyers to evaluate evidence of their opposing counsel. The adversarial system is generally adopted in common law countries. Major common law jurisdictions include the UK, US, Australia and India. On the other hand, continental Europe, which follows the civil law system, i.e., those deriving from Roman law or the Napoleonic Code, has adopted the inquisitorial system. Having understood the basic framework of functioning of the two models of legal systems, let us analyze their advantages and disadvantages. 2. Advantages and disadvantages of adversarial and inquisitorial system. The main advantages of an adversarial system include: I. The use of cross-examination can be an effective way to test the credibility of witnesses presented. E. The parties may be more willing to accept the results when they are given effective control over the process. The disadvantages of an adversarial system are the following. I. The cost of the justice system falls upon the parties. This creates an inbuilt discrimination amongst the litigants. Parties with better resources are able to access justice by hiring competent lawyers and presenting sophisticated evidence which may not be immediately available for parties that lack these resources. Accessibility and affordability to justice are important challenges for the adversarial system of dispute resolution. E. The role of lawyers and the procedural formalities. A. G. Cross-examination may prolong the trial and lead to delays in several matters. E. Judges play a less active role. A judge is not duty-bound to ascertain the truth but only to evaluate the matter based on the evidence presented before him, her. Peter Murphy in his book, Practical Guide to Evidence recounts an instructive example. A frustrated judge in an English, adversarial, court finally asked a barrister after witnesses had produced conflicting accounts, "Am I never to hear the truth?" "No, my lord, merely the evidence," replied counsel. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 35. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. The main advantages of an inquisitorial system include: I. The system offers procedural efficiency. A stay active role of judges prevents delays in prolonged trials. E. The system preserves equality between the parties, as even the stronger party with more resources and expert lawyers may not be able to influence the judges. The disadvantages of this model include: I. In an inquisitorial system, since the judge steps into the shoes of an investigator, she can no longer remain neutral to evaluate the case with an open mind. E. There may be a lack of an incentive structure for judges to involve themselves in proper fact-finding. Activity. Evaluate the features of the Indian legal system. Is it adversarial or inquisitorial? Take 4 case studies and see if the model should change with the change in nature of the case, such as civil, criminal, public interest litigation, etc. 3. Introduction to Alternative Dispute Resolution. Meaning and scope. Alternative dispute resolution, ADR, is an attempt to devise a machinery which should be capable of providing an alternative to the conventional methods of resolving disputes in the court system. ADR refers to the use of non-adversarial techniques of adjudication of legal disputes. The history of ADR in India predates the modern adversarial model of Indian judiciary. The modern Indian judiciary was introduced with the advent of the British colonial era, as the English courts and the English legal system influenced the practice of Indian courts, advocates and judges. Courts in India were established to have in place a uniform legal system on the lines of the English courts. However, even before the advent of such formalistic models of courts and judiciary, the Indian legal system was characterized by several native ADR techniques. The Vedic age in India witnessed the flourishing of specialized tribunals such as Kula, for disputes of family, community, tribe, castes, races; Shreni, for internal disputes in business, corporation of artisans, and Puga, for association of traders, commerce branches. In these institutions, interest-based negotiations dominated, with a neutral third party seeking to identify the underlying needs and concerns of the parties in dispute. Similarly, people's courts, or panchayat, continued to be at the center of dispute resolution in villages. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 36. Unit V Unit 7 Unit V. Did you know? The ancient position of ADR outside India was akin to the submission of disputes to the decision of private persons, recognized under the Roman law by the name of compromisum, compromise. Arbitration was a mode of settling controversies much favored in the civil law of the continent. The Greeks attached particular importance to arbitration. The attitude of English law towards arbitration fluctuated from stiff opposition to moderate welcome. The common law courts looked jealously at agreements to submit disputes to extrajudicial determination. Source: Russell on Arbitration, 22 NDEDN, 2003, p. 362, para 8002. Alternative Dispute Resolution, ADR, which at one point of time was considered a voluntary action on the part of the parties, has now obtained statutory recognition with the enactment of Arbitration and Conciliation Act, 1996 and the Legal Services Authority Act, 1987. The incorporation of ADR mechanisms under Section 89 of Code of Civil Procedure, 1908 is one more radical step taken by legislature for promoting ADR in India. Section 89 CPC, Settlement of Disputes Outside the Court. 1. Where it appears to the court that there exist elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations, and after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for a. Arbitration, b. Conciliation, c. Judicial settlement including settlement through Lok Adalat, or d. Mediation. The purpose of this section is to enable the courts to legally refer the matters to ADR to dispose of the cases expediently and to reduce the backlog. In the modern era, several new and sophisticated forms of ADR techniques have developed. The different forms of ADR models, techniques are discussed in the subsequent parts of the chapter. IV. Problems faced by courts. The law courts are confronted with following problems, such as 1. The lack of number of courts and judges, which creates an inadequacy within the justice delivery system. 2. The increasing litigation in India due to increasing population, complexity of laws and obsolete continuation of some pre-existing legal statutes. 3. The increasing cost of litigation in prosecuting or defending a case, increasing court fees, lawyers' fees and incidental expenses. 4. Delay in disposal of cases resulting in huge pendency in all the courts. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 37. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. V. Benefits of ADR. The ADR techniques are a speedier, informal and cheaper mode of dispensing justice when compared to the conventional judicial procedure. Following are the benefits of ADR. It is less time-consuming as people resolve their disputes expeditiously in a short period as compared to courts. It is less costly than litigation. It is free from technicalities of courts as informal ways are applied in resolving disputes. It can be used at any time, even when a case is pending before a court of law, though recourse to ADR as soon as the dispute arises may confer maximum advantages on the parties. It provides a more convenient forum to the parties who can choose the time, place and procedure for conducting the preferred dispute redressal process. If the dispute is technical in nature, parties have an opportunity to select the expert who possesses the relevant legal and technical expertise. It is interesting to note that ADR provides the flexibility to even refer disputes to non-lawyers. For example, several disputes of technical character, e.g. disputes pertaining to the regulation of the construction industry, are usually referred to engineers rather than lawyers. ADR is based on more direct participation by the disputants rather than being run by lawyers and judges. This type of involvement is believed to increase people's satisfaction with the outcome as well as their compliance with the settlement reached. In the light of the apparent need and benefits provided by ADR, it has emerged as a successful alternative to court trials. Further, the rise of the ADR movement in India indicates that it is contributing tremendously towards reviving the litigants' faith in justice delivery mechanisms. VI. Types of ADR. A. Arbitration. A. 1. Introduction. The law relating to arbitration is contained in the Arbitration and Conciliation Act, 1996. It came into force on the 25th day of January, 1996. But it goes much beyond the scope of its predecessor, the Arbitration Act of 1940. It provides for domestic arbitration, international commercial arbitration and also enforcement of foreign arbitral awards. It also contains the new feature on conciliation. Recently, the Arbitration and Conciliation Amendment Act, 2015 has come into force to meet the requirements of alternative resolutions. The Arbitration and Conciliation Act of 1996 is the relevant legislation that governs the process of arbitration in India. The statute provides for an elaborate codified recognition of the concept of arbitration, which has largely been influenced by significant movements of judicial reforms and conflict management across the world. In this regard, a special reference must be made to an international convention entitled United Nations Commission on International Trade Law, UNCITRAL, Model Law on International Commercial Arbitration, 1985. After the birth of this international treaty, the United Nations General Assembly, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 38. Unit V Unit 7 Unit V. Recommended that all countries must give due consideration to the said model law, in order to bring uniformity in the law and practice of international arbitration. The Indian Arbitration and the Conciliation Act of 1996 is similarly modeled on the UNCITRAL model law. A. 2. Meaning. Arbitration is a term derived from the nomenclature of Roman law. Arbitration is a private arrangement of taking disputes to a less adversarial, less formal and more flexible forum and abiding by judgment of a selected person instead of carrying it to the established courts of justice. A. 3. Process of arbitration. Step 1. Notice. The party aggrieved will send a notice to the defaulting party initiating arbitration. Step 2. Choose an arbitrator. The parties in an arbitration have the freedom to select a qualified expert known as an arbitrator. Arbitration agreement. An agreement whereby parties agree to submit their present or future disputes, differences to arbitration. This may be in writing or via other means of communication. Court referral to arbitration. If a party to the dispute approaches the court despite the presence of an arbitration agreement, the other party may raise a claim before the court. The court then must refer the dispute back to arbitration, if it has been previously agreed by the parties. This method of initiating arbitration is known as court referral to arbitration. Step 3. Statement of claim. The initial documents filed by the claimants enlisting the issues raised to be resolved in an arbitration. Step 4. Statement of counterclaim. Respondents reply to the claim presented by the claimant. Step 5. Proceedings start. Decide the place and time to meet. The process of dispute resolution through arbitration is confidential, unlike the court proceedings which are open to the public. This feature of arbitration makes it popular especially for commercial disputes where business secrets revealed during the process of dispute resolution are protected and preserved. Similarly, companies can maintain their commercial reputation, as they can prevent the general public or their customers from discovering the details of their ongoing legal disputes. Step 6. Award. The decision rendered by an arbitrator is known as an arbitral award. Similar to a judgment given by a judge, the arbitral award is binding on the disputing parties. Once an arbitral award is rendered, it is recognized and enforced, given effect to, akin to a court-pronounced judgment or order. In addition to an arbitral award, the arbitrator also holds power and authority to grant interim measures, like a judge in the court. These interim measures, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 39. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Are in the nature of a temporary relief and may be granted while the legal proceedings are ongoing in order to preserve and protect certain rights of the parties, till the final award is rendered. Therefore, an arbitral award holds several similarities with a court order or judgment. However, unlike a judgment rendered by a judge in the court, the award does not hold precedential value. See the doctrine of stare decisis, which means, stand by the decision, for future arbitrations. Arbitrators are free to base their decisions on their own conception of what is fair and just. Thus, unlike judges, they are not strictly required to follow the law or the reasoning of earlier case decisions. A. 3.1 Setting aside of an arbitral award. An arbitral award rendered in an arbitration may be struck down or invalidated by the courts. The grounds of such invalidation are limited to incapacity of a party to enter into arbitration agreement in the first place, improper appointment of arbitrator, dispute falling outside the terms of the arbitration agreement, bias on the part of arbitrator, award violating public policy at large. A. 4 types of arbitration. Domestic arbitration, the arbitration in which the arbitral proceedings are held in India and both the parties to the dispute also belong to India, and the dispute is decided in accordance with the substantive and procedural laws of India. Foreign arbitration, an arbitration where arbitral proceedings are conducted in a place outside India but the arbitral award is required to be enforced in India. Ad hoc arbitration, an arbitration which is governed by parties themselves, without recourse to a formal arbitral institution. It may be domestic or international in character. Ad hoc arbitration means that the arbitration should not be conducted according to the rules of an arbitral institution. Since parties do not have an obligation to submit their arbitration to the rules of an arbitral institution, they are free to state their own rules of procedure. Institutional arbitration, an arbitration where parties select a particular institution, which in turn takes the arbitration forward by selecting an arbitrator and laying out the rules applicable. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 40. Unit V Unit 7 Unit V. Within an arbitration, e.g., mode of obtaining evidence, etc. There are several institutions to govern arbitration. Examples of prominent institutions of arbitration include the London Chamber of International Arbitration, LCIA, which has its offices across the world, including New Delhi, India. Statutory arbitration. This type of arbitration emanates from an enactment of the Parliament or state legislature. In such a case, parties have no option as such but to abide by the law of the land. The consent of parties is not necessary and is a compulsory form of arbitration. For example, the Defence of India Act, 1971 is one such legislation that mandates a recourse to arbitration in case of any dispute arising within the Act. International commercial arbitration, an arbitration in which at least one of the disputing parties is a resident, body corporate of a country other than India. Arbitration with the government of a foreign country is also considered to be an international commercial arbitration. This form of arbitration has been defined specifically under Section 2(1)(f) of the Arbitration and Conciliation Act, 1996. Bharat Aluminum Company Limited, Balco, V.S. Kaiser Aluminum Technical Service, Inc. Kaiser, 2012 SC. In Bhatia International V Bulk Trading S. ANANR. Bhatia International, 2002, the Supreme Court had held that Part 1 of the Arbitration and Conciliation Act, 1996, Act, setting out the procedures, award, interim relief and appeal provisions with respect to an arbitration award, would apply to all arbitrations held out of India, unless the parties by agreement, express or implied, exclude all or any of its provisions. The Supreme Court set aside the doctrine in Balco v. Kaiser. Brief facts. 1. An agreement dated the 22nd of April 1993, agreement, was executed between Balco and Kaiser, under which Kaiser was to supply and install a computer-based system at BALCO's premises. 2. As per the arbitration clause in the agreement, any dispute under the agreement would be settled in accordance with the English arbitration law and the venue of the proceedings would be London. The agreement further stated that the governing law with respect to the agreement was Indian law. However, arbitration proceedings were to be governed and conducted in accordance with English law. 3. Disputes arose and were duly referred to arbitration in England. The arbitral tribunal passed 2 awards in England which were sought to be challenged in India U.S. 34 of the Act in the District Court at Bilaspur. Successive orders of the District Court and the High Court of Chhattisgarh rejected the appeals. Therefore, Balco appealed to the Supreme Court. 4. Another significant issue to be adjudged was applicability of Section 9, interim measures, of the Act. 5. During the pendency of arbitration proceedings in London, an injunction application was made by appellants, Bharti Shipyard Limited, before the district judge at Mangalore, against the encashment of refund bank guarantees issued under the contract, U.S. 9 of the Act. The applications were allowed and were consequently challenged in the High Court of Bangalore. The Bangalore High Court set aside the application so allowed on the Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 41. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Grounds that the appellants had an alternative remedy, U.S. 44 of the Act, being interim reliefs for international arbitration, in the courts of London and further since the substantive law governing the contract, as well as the arbitration agreement, is English law, the English courts should be approached. This was also challenged in this petition to the Supreme Court. Held. The judgment in detail analyzes the provisions of various sections in the Act and applicability of Part 1 of the Act to international commercial arbitrations. Some significant issues dealt with in the judgment are as follows. 1. It was observed that the object of Section 2(7) of the Act is to distinguish the domestic award, Part 1 of the Act, from the foreign award, Part 2 of the Act. 2. It was held that there is a clear distinction between Part 1 and Part 2 as being applicable in completely different fields and with no overlapping provisions. 3. The court has also drawn a distinction between a seat and venue, which would be quite crucial in the event the arbitration agreement designates a foreign country as the seat, place, of the arbitration and also select the Act as the curial law governing the arbitration proceedings. The court further clarified that the choice of another country as the seat of arbitration inevitably imports an acceptance that the law of that country relating to the conduct and supervision of arbitrations will apply to the proceedings. It would, therefore, follow that if the arbitration agreement is found held to provide for a seat, place of arbitration outside India, then even if the contract specifies that the Act shall govern the arbitration proceedings, Part 1 of the Act would not be applicable or shall not enable Indian courts to exercise supervisory jurisdiction over the arbitration or the award. Therefore, it can be inferred that Part 1 applies only to arbitrations having their seat, place in India. 4. The court dissented with the observations made in Bhatia International case and further observed on a logical construction of the Act, that the Indian courts do not have the power to grant interim measures when the seat of arbitration is outside India. 5. The court further held that in foreign-related international commercial arbitration, no application for interim relief will be maintainable in India, either by arbitration or by filing a suit. Conclusion of the Balco case. The court in this case also drew a distinction between a seat and venue. The arbitration agreement designates a foreign country as the seat, place of the arbitration and also selects the act as the law governing the arbitration proceedings. The court also clarified that the choice of another country as the seat of arbitration inevitably imports an acceptance that the law of that country relating to the conduct and supervision of arbitrations will apply to the proceedings. Therefore, it can be understood that Part 1 applies only to arbitrations having their seat, place in India. However, the 2015 Amendment Act has compensated for some of the shortcomings in Balco by adding a provision to S. 2 of the Act which laid down that the provision for interim relief by the court, S. 9, shall be applicable to even foreign-seated arbitrations. The Arbitration and Conciliation Act, 1996 has ushered a new era of dispute resolution for domestic and commercial legal issues. On these lines, the Supreme Court of India has also affirmed that the Arbitration and Conciliation Act, 1996 was introduced in order to attract the international mercantile community. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 42. Unit V Unit 7 Unit V. In Konkan Railways Corp. Limited. V. M. S. Mehul Construction Company. 2007 SCC 201. The Honorable Supreme Court has emphasized that the increasing growth of global trade and the delay in disposal of cases in courts under the normal system in several countries made it imperative to have the perception of an alternative dispute resolution system, more particularly, in the matter of commercial disputes. When the entire world was moving in favor of a speedy resolution of commercial disputes, the United Nations Commission on International Trade Law way back in 1985 adopted the UNCITRAL Model Law of International Commercial Arbitration, and since then, a number of countries have given recognition to that model in their respective legislative system. With the said UNCITRAL Model Law in view, the present Arbitration and Conciliation Act of 1996 has been enacted in India. The Arbitration Act of 1996 provides not only for domestic arbitration but spreads its sweep to international commercial arbitration too. All these aim at achieving the sole object to resolve the dispute as expeditiously as possible with the minimum intervention of a court of law so that the trade and commerce is not affected on account of litigations before a court. With that objective, when the UNCITRAL model has been prepared and the Parliament in our country enacted the Arbitration and Conciliation Act of 1996 adopting UNCITRAL, it would be appropriate to bear the said objective in mind while interpreting any provision of the Act. In Fuad de Lawson Limited vs Jindal Exports Limited, Air 2001 SC, the Supreme Court observed that the object of the Arbitration and Conciliation Act of 1996 is to provide speedy and alternative solution to the dispute and avoid protraction of litigation. The provisions of the Act have to be interpreted accordingly. B. Mediation. B. 1 Meaning and types. Mediation is a method of ADR in which parties appoint a neutral third party who facilitates the mediation process in order to assist the parties in achieving an acceptable, voluntary agreement. Mediation is premised on the voluntary will of the parties and is a flexible and informal technique of dispute resolution. Mediation is more formal than negotiation but less formal than arbitration or litigation. Unlike litigation and similar to arbitration, mediation is relatively inexpensive, fast, and confidential. Further, mediation and arbitration differ on the grounds of the nature of an award rendered. The outcome of mediation does not have similar binding like an arbitral award. However, though non-binding, these resolution agreements may be incorporated into a legally binding contract, which is binding on the parties who execute the contract. Mediation can be classified into the following categories. Evaluative mediation. Evaluative mediation is focused on providing the parties with an evaluation of their case and directing them towards settlement. During an evaluative mediation process, when the parties agree that the mediator should do so, the mediator will express a view on what might be a fair or reasonable settlement. The evaluative mediator has somewhat of an advisory role in that he evaluates the strengths and weaknesses of each side's argument and makes some predictions about what would happen should they go to court. Facilitative mediation. Facilitative mediators typically do not evaluate a case or direct the parties to a particular settlement. Instead, the facilitative mediator facilitates the conversation. These mediators act as guardian of the process, not the content or the outcome. During a facilitative mediation session, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 43. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. The parties in dispute control both what will be discussed and how their issues will be resolved. Unlike the transformative mediator, the facilitative mediator is focused on helping the parties find a resolution to their dispute. The facilitative mediator further provides a structure and agenda for the discussion. Transformative mediation. Transformative mediation practice is focused on supporting empowerment and recognition shifts by allowing and encouraging deliberation, decision-making, and perspective-taking. A competent transformative mediator practices with a micro-focus on communication, identifying opportunities for empowerment and recognition as those opportunities appear in the parties' own conversations, and responding in ways that provide an opening for parties to choose what, if anything, to do with them. Mediation with arbitration. Mediation has sometimes been utilized to good effect when coupled with arbitration, particularly binding arbitration, in a process called mediation, arbitration. The process begins as a standard mediation, but if mediation fails, the mediator becomes an arbiter. This process is more appropriate in civil matters where rules of evidence or jurisdiction are not in dispute. It resembles, in some respects, criminal plea bargaining and confusion judicial procedure, wherein the judge also plays the role of prosecutor. Despite their benefits, mediation, arbitration hybrids can pose significant ethical and process problems for mediators. Many of the options and successes of mediation relate to the mediator's unique role as someone who wields no coercive power over the parties or the outcome. The party's awareness that the mediator might later act in the role of judge could distort the process. Using a different individual as the arbiter addresses this concern. Online mediation. Online mediation employs online technology to provide disputants access to mediators and each other despite geographic distance, disability or other barriers to direct meeting. B. 2. Process of mediation. The neutral third party facilitating the process of mediation is known as a mediator. Mediation does not follow a uniform set of rules, though mediators typically set forth rules that the mediation will observe at the outset of the process. Successful mediation often reflects not only the parties' willingness to participate but also the mediator's skill. There is no uniform set of rules for mediators to become licensed, and rules vary by state regarding requirements for mediator certification. Broadly speaking, mediation may be triggered in three ways. I. Parties may agree to resolve their claims through a pre-agreed mediation agreement without initiating formal judicial proceedings, pre-litigation mediation. Pre-litigation mediation is not yet governed by any law in India. E. Parties may agree to mediate, at the beginning of formal court proceedings, popularly known as court referrals. This is governed by Section 89 of the Code of Civil Procedure. E. Mediation may be taken recourse of, after formal court proceedings have started, or even post-trial, i.e. at the appellate stage. Under the Indian law, contractual dispute, including money claims, similar disputes arising from strained relationships, from matrimonial to partnership, disputes which need a continuity of relationship, neighbors' easement rights, and consumer disputes have been held to be most suited for mediation. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 44. Unit V Unit 7 Unit V. For example, a suburban homeowner might find that the formal legal system offers no realistic way to deal with his neighbor's overly bright driveway lights that shine in his bedroom window. Such disputes, however, can be mediated. Mediation gives the participants an opportunity to raise and discuss any issues they might wish to settle. For example, it might turn out that the neighbor lit his driveway because the homeowner's dog went on his lawn, or because the homeowner's tree was encroaching upon his property. Because mediation can handle any number of outstanding gripes or issues, it offers a way to discuss and solve the problems underlying a dispute and creating a truly lasting peace. The Supreme Court of India in its judicial decision has expressly clarified the ambit of mediation. According to Afcons Infrastructure Limited. V. Cherian Varke Construction Company. P. Limited. 2010, 8 SCC 24, Representative Suits, Election Disputes, Criminal Offences, Case against specific classes of persons, minors, mentally challenged, have been excluded from the scope of mediation. Activity. Identify a situation in which you would choose mediation as your preferred method of dispute resolution. Why is mediation the best method in this situation? What are the potential benefits and drawbacks of mediation in this situation? C. Conciliation. C. 1 Concept. Part 3 of the Arbitration and Conciliation Act, 1996 deals with conciliation. Conciliation means the settling of disputes without litigation. Conciliation is a process by which discussion between parties is kept going through the participation of a conciliator. Conciliation is a process similar to mediation, as parties out of their own free will appoint a neutral third party to resolve their disputes. The key difference between mediation and conciliation lies in the role of the neutral third party. A mediator merely performs a facilitative role and provides a platform for the parties to reach a mutually agreeable solution. The role of a conciliator goes beyond that of a mediator. A conciliator may be interventionist in the sense that she may suggest potential solutions to the parties in order to resolve their claims and disputes. If the parties reach agreement on the settlement of a dispute, a written settlement agreement will be drawn up and signed by the parties. If the parties request, the conciliator may draw up or assist the parties in drawing up the settlement agreement. Section 73(2) of the Arbitration and Conciliation Act, 1996. When the parties have signed the settlement agreement, it becomes final and binding on the parties and persons claiming under them respectively. Section 73(3) of the Act. The settlement agreement shall have the same status and effect as an arbitral award. This means it shall be treated as a decree of the court and shall be enforceable as such. Haresh Dayaram Thakur v. State of Maharashtra, Air 2000 South Carolina 2281, Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 45. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Conciliation is also governed by Section 89, a provision inserted by the 2002 amendment of the Civil Procedure Code, 1908, for short, CPC. The code is the primary legislation governing the method, procedure and legal practice of civil disputes. Similarly, conciliation only finds a reference in Section 89, Civil Procedure Code, 1908. The process and methods within conciliation have been described in the Arbitration and Conciliation Act, 1996. Further, the Industrial Disputes Act, 1947 also provides for conciliation as a viable means of resolving disputes in the labor sector. D. Lok Adalat. The concept of Lok Adalat, People's Court, is an innovative Indian contribution to the global legal jurisprudence. The institution of Lok Adalat in India, as the very name suggests, means People's Court. Lok stands for people, and the term Adalat means court. India has a long tradition and history of such methods being practiced in the society at grassroots level. In ancient times, the disputes were referred to panchayats, which were established at village level. Panchayats used to resolve the dispute through arbitration. It has proved to be a very effective alternative to litigation. This very concept of settlement of dispute through mediation, negotiation or through arbitral process known as decision of Nyay Panchayat is conceptualized and institutionalized in the philosophy of Lok Adalat. It involves people who are directly or indirectly affected by dispute resolution. The evolution of movement called Lok Adalat was a part of the strategy to relieve heavy burden on the courts with pending cases and to give relief to the litigants who were in a queue to get justice. The modern institution of Lok Adalat is presided over by a retired judicial officer such as the chairman, with usually two other members, a lawyer and a social worker. A Lok Adalat has jurisdiction to settle any matter pending before any court, as well as matters at pre-litigative stage, i.e., disputes which have not yet been formally instituted in any court of law. Such matters may be in the nature of civil or compoundable criminal disputes. The salient features of Lok Adalat are participation, accommodation, fairness, voluntariness, neighborliness, transparency, efficiency and lack of animosity. D. 1. The benefits of Lok Adalat include: there is no court fee, and even if the case is already filed in the regular court, the fee paid will be refunded if the dispute is settled at the Lok Adalat. There is no strict application of the procedural laws and the disputing parties can directly interact with the judges. The decision of Lok Adalat is binding on the parties and its order is capable of execution through legal process. Did you know? The first Lok Adalat was held on March 14, 1982 at Junagadh in Gujarat. Lok Adalats have been very successful in settlement of claims including motor accident claims, matrimonial, family disputes, labor disputes, disputes relating to public service such as telephone, electricity, bank recovery cases etc. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV 46. Unit V Unit 7 Unit V. Activity. I had learned the true practice of law. I had learned to find out the better side of human nature, and to enter men's hearts. I realized that the true function of a lawyer was to unite parties riven asunder. The lesson was so indelibly burnt into me that the large part of my time during the 20 years of my practice as a lawyer was occupied in bringing about private compromises of hundreds of cases. I lost nothing thereby, not even money, certainly not my soul. Gandhi, in the light of the aforesaid quote, evaluate the role of lawyers as social engineers. What role do ADR techniques and institutions such as Lok Adalat play in this respect? F. Ombudsman. An indigenous Swedish, Danish and Norwegian term, ombudsman is etymologically rooted in the word embosarnaur, essentially meaning representative. Whether appointed by a legislature, the executive, or an organization, the typical duties of an ombudsman are to investigate complaints and attempt to resolve them, usually through recommendations, binding or not, or mediation. Ombudsmen sometimes also aim to identify systemic issues leading to poor service or breaches of people's rights. At the national level, most ombudsmen have a wide mandate to deal with the entire public sector, and sometimes also elements of the private sector, for example, contracted service providers. Further redress depends on the laws of the country concerned, but this typically involves financial compensation. The Government of India has designated several ombudsmen, sometimes called Chief Vigilance Officer, CVO, for the redress of grievances and complaints from individuals in the banking, insurance and other sectors being serviced by both private and public bodies and corporations. For example, the CVC, Central Vigilance Commission, was set up on the recommendation of the Santhanam Committee, 1962-64. CVC has been conceived to be the apex vigilance institution, free of control from any executive authority, monitoring all vigilance activity under the central government and advising various authorities in central government organizations in planning, executing, reviewing and reforming their vigilance work. About Banking and Insurance Ombudsman. What is the Banking Ombudsman Scheme? The Banking Ombudsman Scheme is an expeditious and inexpensive forum for bank customers for resolution of complaints relating to certain services rendered by banks. Presently, the Banking Ombudsman Scheme 2006, as amended up to July 1, 2017, is in operation. Who is a Banking Ombudsman? The Banking Ombudsman is a senior official appointed by the Reserve Bank of India to redress customer complaints against deficiency in certain banking services covered under the grounds of complaint specified under the Banking Ombudsman Scheme 2006, as amended up to July 1, 2017. Who is an Insurance Ombudsman? The Insurance Ombudsman are appointed by the Council for Insurance Ombudsman in terms of Insurance Ombudsman Rules, 2017, as amended from time to time, and Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 47. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. Empowered to receive and consider complaints alleging deficiency in performance required of an insurer, including its agents and intermediaries, or an insurance broker. The major advantage of an ombudsman is that he or she examines complaints from outside the offending state institution, thus avoiding the conflicts of interest inherent in self-policing. G. Lokpal and Lokayukt. A Lokpal, caretaker of people, is an ombudsman in India. The Lokayukt, appointed by the people, is a similar anti-corruption ombudsman organization in the Indian states. The institutions of Lokpal and Lokayukt were given formal recognition by the passing of the Lokpal and Lokayukt Act, 2013. The legislation aims to combat acts of bribery and corruption of public servants, a term that has been given a fairly wide interpretation in the Act. The Act applies to the public servants in and outside India. It is important to note that the Act includes in its purview even the current and ex-Prime Ministers of India except in matters pertaining to international relations, external and internal security, public order, atomic energy and space. At least two-thirds of the members of Lokpal must approve of such an inquiry. It further provides that any such inquiry shall be held in camera, and if the Lokpal comes to the conclusion that the complaint deserves to be dismissed, the records of the inquiry shall not be published or made available to anyone. Besides the Prime Minister, it brings within its purview any person who is or has been a Minister of the Union and any person who is or has been a member of either House of Parliament. The Lokpal shall not inquire into any matter involved in, or arising from, or connected with, any such allegation of corruption against any member of either House of Parliament in respect of anything said or a vote given by him, her in Parliament or any committee thereof covered under the provisions contained in Clause 2 of Article 105 of the Constitution. With respect to bureaucracy, it includes any group, A, B, C, or D, official or equivalent from amongst the public servants defined in the Prevention of Corruption Act, 1988 when serving or who has served in connection with the affairs of the Union. The Act also provides for the manner in which the public servants must declare their assets. According to the Act, the Lokpal shall consist of a chairperson who has been a Chief Justice of India or is or has been a judge of the Supreme Court or is an eminent judicial member of impeccable integrity and outstanding ability, having special knowledge and expertise of not less than 25 years in matters relating to anti-corruption policy, public administration, vigilance or finance. Further, the total members of Lokpal shall not exceed 8, out of whom 50% shall be judicial members. Furthermore, the powers of the Lokpal are extensive, and equivalent to the superintendence, inquiry and investigative powers of the police and the Central Vigilance Commission. The Lokpal shall consist of an inquiry and prosecution wing to take necessary steps in prosecution of public servants in relation to offences committed under the Prevention of Corruption Act, 1988. Further, Lokpal can even recommend the government to create special courts to decide cases arising from the prevention. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 48. Unit V Unit 7 Unit V. Of Corruption Act, 1988. Likewise, the Lokpal and Lokayukts Act, 2013 provides for the establishment of Lokayukt in every state in order to deal with complaints of corruption against public functionaries. The Act provides that all states must institute Lokayukts within 1 year from the date of the commencement of the Lokpal and Lokayukts Act, 2013. It is important to note that even before the enactment of this Act, some states in India, for example, Delhi, Karnataka, Kerala, etc. had the institutions of Lokayukts in place. Did you know? Maharashtra was the first state to introduce the institution of Lokayukt in 1971. Conclusion. The ADR or Alternative Dispute Resolution is an attempt to devise a machinery which should be capable of providing an alternative to the conventional methods of resolving disputes. Courts have become overcrowded with litigants. Due to the large pendency of cases in the courts, litigants have to face so much loss of time and money that at long last, when a relief is obtained, it may not be worth the cost. A large number of quasi-judicial and administrative tribunals have been created for quicker relief. All these tribunals and forums are in a way an alternative method of dispute redressal. But even such tribunals and forums have become overcrowded, with the result that they are not able to provide relief within good time. Many tribunals in service matters have been able to provide relief only when the aggrieved employee has already retired from his position. Relief in terms of money which he may ultimately get may not be worth the service period lost. Consumer forums came into being to provide quick, effective and costless relief to buyers of goods and hirers of services. Persons suffering from poor quality of merchandise and services in the market turned out to be so great in number that consumer redressal forums and commissions have proved to be inadequate to the volume of complaints. Heavy pendency causes long delays. In a large number of cases, a delayed consumer remedy serves no purpose. Thus, official consumer remedies have also lost their swiftness. Furthermore, they are not able to provide any remedy for non-consumer matters. There thus remains the need for an alternative remedy which will not be bogged down by costs and delays. The institutional framework for providing the area services is not yet fully developed. All that can be said is that, now the ADR is rapidly developing its own national institutions, experience, and theoretical and practical development, and at the same time offering a simpler cross-border dispute resolution approach. Exercises. Based on your understanding, answer the following questions. 1. Ram and Sikandar agreed in writing to resolve the disputes arising out of their contract by way of arbitration. A dispute arose between Ram and Sikandar. Ram filed a case in the court. Will the court stay the legal proceedings filed by Ram? Discuss. 2. Mr. Hari and his friend, Mr. Suresh, entered into a partnership deed to carry on the business of creative designing. After a year of starting a successful partnership firm, creative differences arose between Mr. Hari and Mr. Suresh, which created a rift between them. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In 49. Unit I. UNITII Unit 3 Unit IV. UNITV. Unit V Unit 7 Unit V. To help resolve the dispute, Mr. Sharma, the secretary of a reputed firm, is facilitating them to help them achieve an acceptable agreement. Which dispute resolution method is Mr. Sharma resorting to? Explain. 3. Sita and Reena are business partners. After some time, a dispute arose between them. Both of them agreed to submit the dispute between them to Mr. Bajaj, a senior member of a law firm. Sita subsequently came to know that Reena and Mr. Bajaj are related to each other. Can Sita challenge the authority of Mr. Bajaj as an arbitrator? Discuss. 4. What is the meaning of ombudsman? Identify equivalent institutions within India. Discuss their roles and limitations. 5. A dispute arose between Rakesh and his employer regarding some incident of injustice to Rakesh by some senior members of the management during the course of his employment. They appointed Mr. Kumar to resolve the dispute. Mr. Kumar not only facilitated the conversation but also suggested potential solutions. Identify and explain the role played by Mr. Kumar. 6. A Lokpal is an ombudsman in India, while a Lokayukt is a similar anti-corruption ombudsman organization in the Indian states. A. Elaborate on the scope of the Lokpal and Lokayukt Act, 2013. B. Explain the composition of Lokpal under the Act. 7. The concept of Lok Adalat is an innovative Indian contribution to the global legal jurisprudence. Analyze the features of Lok Adalat that make it a suitable forum for alternative dispute resolution. Textbook of Legal Studies XII 2023-2024. www. CBSE Academic. NIC. In. Unit I. UNITII. Unit 3 Unit IV. UNITV. 50. Unit V Unit 7 Unit V. Bibliography 1. Law of Arbitration and Conciliation, Avtar Singh. 2. Alternative Dispute Resolution, The Indian Perspective, Shashank Garg. 3. Law and Practice of Alternative Dispute Resolution, Anirban Chakrabarti. 4. Alternative Dispute Resolution by Dr. S.C. Tripathi. 5. Web links. 6. Web links. 7. Web links commentaries. 8. McCalla Priles, ed. Dispute Resolution in Asia, 2nd end. 12 to 153. 9. Agrawal, Role of Alternative Dispute Resolution Methods in Development of Society. Lok Adalat, in India. IIM Ahmedabad, WP number. The 1st of November 2005, November 2005. Web resources. 10. K. Joachim, Pros and Cons of Adversarial v. Inquisitorial Adjudication, available at. Web links. 11. Alternative Dispute Resolution, Web links 3, CHAPTER 44. 12. Administrative Tribunal, Web links PHP. ID equals 36. 13. Mediation, Web links 14. Central Administrative Tribunal, Web links. 15. Ombudsman Wikipedia Web links. 16. Lokpal Web links. 17. Lokayukt Web links. 18. Center for Policy Analysis, Lokpal and Draft Jan Lokpal Bill, a comparison. 19. Web links Press and Blogs. 20. All About Lokayukt, The Hindu, January 4, 2012 Unit 3. Law I, Business Law. Textbook of Legal